Key labor law judgments from Indian high courts. This curated collection examines landmark decisions that have fundamentally reshaped India's employment legal landscape across multiple jurisdictions. Authoritative compilation of pivotal rulings on EPF, ESIC, wages, gratuity, and employment matters from various high courts and the Supreme Court of India. In-depth analysis of precedent-setting cases that definitively clarify employer obligations and employee rights under India's nuanced labor law framework. Critical examination of recent judicial interpretations that significantly impact compliance requirements for businesses operating in India. Strategic focus on resolving contradictory rulings between different high courts and illuminating subsequent Supreme Court resolutions. Essential insights for HR professionals, legal advisors, and business leaders developing comprehensive employment policies and compliance strategies. These seminal judgments represent watershed developments in Indian labor jurisprudence that profoundly influence workplace practices, statutory compliance frameworks, and employer-employee relationships across diverse industry sectors. Trial court cannot issue summons to the employer when order passed under Section 7A was stayed. Key points from the landmark Punjab and Haryana High Court ruling. Legal principle. When a judicial stay is granted on an order under Section 7A of the EPF Act, trial courts lack jurisdiction to proceed with prosecution until the stay is vacated. Background on Section 7A. This provision empowers EPF authorities to determine employers' provident fund contribution liabilities. These determinations remain subject to judicial review and challenge. Case context. The employer had successfully challenged the Section 7A determination order and secured a judicial stay pending final adjudication on the merits. Court ruling. The High Court unequivocally held that trial courts cannot issue summons to employers while the underlying Section 7A order remains under judicial stay. Legal reasoning. The court emphasized that continuing prosecution during a valid stay would contravene judicial authority and potentially inflict irreparable damage to employers' interests. Practical implication. This ruling provides crucial protection for employers facing disputed EPF assessments, effectively preventing premature enforcement actions during ongoing legal review. Precedential value. This judgment establishes a significant procedural safeguard for employers contesting EPF contribution determinations throughout the court's jurisdiction. Writ petition against S-14B order is maintainable when EPF authority fails to properly exercise jurisdiction. The Meghalaya High Court established a significant legal precedent regarding judicial review of orders under the Employees Provident Fund (EPF) Act. Legal issue. The court addressed whether writ petitions challenging orders under Section 14B of the EPF Act are maintainable despite existing statutory remedies. Court ruling. The Meghalaya High Court definitively held that writ petitions are maintainable when EPF authorities demonstrably fail to exercise their jurisdiction properly or commit procedural irregularities. Legal principle. When statutory authorities fail to exercise their jurisdiction as mandated by law, their decisions become subject to direct judicial review through writ jurisdiction, effectively bypassing the standard appellate process. Key findings. The court determined that EPF authorities' failure to consider statutorily relevant factors or actions exceeding their prescribed mandate renders their orders susceptible to immediate judicial challenge. Precedential impact. This landmark judgment clearly delineates the specific circumstances under which employers may directly petition high courts instead of navigating the lengthy statutory appeal mechanism. Practical significance. Employers confronting arbitrary or procedurally defective orders under Section 14B now possess a valuable additional legal recourse when administrative appeals would likely prove futile. This carefully reasoned ruling strikes an essential balance between administrative efficiency and constitutional safeguards against arbitrary executive action, reinforcing the vital supervisory role of high courts within the EPF dispute resolution framework. High Court can stay garnishee proceedings when appeals are pending before non-functional tribunals. The Kerala High Court established a significant legal precedent regarding EPF recovery actions when appellate mechanisms are unavailable. Statutory appeal. When a party files an appeal against an EPF authority order, they have properly exercised their statutory right under the EPF Act, following the prescribed legal pathway for challenging adverse decisions. 1. Appellate forum unavailable. When the designated tribunal is non-functional or improperly constituted, appellants face a procedural dead end. Their right to appeal exists but cannot be meaningfully exercised through no fault of their own. 2. Recovery despite pending appeal. If EPF authorities nevertheless initiate recovery through garnishee orders against bank accounts and debtors, this effectively nullifies the appellant's statutory right to challenge the original order. 3. Constitutional jurisdiction. The Kerala High Court ruled that in such exceptional circumstances, it can exercise its extraordinary powers under Article 226 of the Constitution to intervene and stay recovery proceedings. 4. Principles of justice. the court determined that allowing recovery when appeal rights cannot be exercised due to institutional failures would violate natural justice principles and undermine the rule of law. 5. Pragmatic resolution. This judgment effectively balances the legitimate recovery interests of authorities against the fundamental right of appellants to have their case properly heard before facing financial consequences. 6. This landmark ruling protects parties from being penalized due to systemic failures in the appellate mechanism, and reaffirms the High Court's crucial role as guardian of constitutional rights when standard legal remedies are effectively unavailable. EPFO must provide comprehensive details justifying damage calculations with proper methodology. The Calcutta High Court established critical standards regarding EPFO damage assessments. Transparency mandate. The Calcutta High Court definitively ruled that EPFO must provide detailed explanations for all damage calculations, including the complete methodology used to determine final assessments. Methodological rigor required. EPFO cannot impose damages without demonstrating a clear, systematic approach behind the calculated amounts. The court emphasized that arbitrary or unexplained calculations would be deemed invalid. Dual justification standard. The authority must explicitly articulate both the quantitative methodology and substantive reasoning behind specific damages awarded in each case, including identifying the precise statutory violations that warranted penalties. Procedural safeguards. Employers must be afforded adequate opportunity to comprehend and contest damage calculations before such assessments are finalized and enforced. Documentation requirements. All damage calculations must be meticulously documented with specific references to the relevant provisions of the EPF Act and applicable rules that authorize such penalties. Evidentiary responsibility. The court unequivocally established that the burden of demonstrating the validity and accuracy of damage calculations rests entirely with the EPFO, not with the employer. This landmark ruling significantly enhances administrative accountability and ensures that employers can fully understand and, where appropriate, effectively challenge the legal and factual basis for any damages imposed by the EPFO. EPF authorities cannot challenge the order passed by the tribunal after a delay of 5-6 years. The Madras High Court decisively rejected EPFO's belated challenge based on these critical factors. Tribunal order. The EPF tribunal had issued its original ruling after comprehensive examination of all evidence and legal arguments. The tribunal's judgment contained clear reasoning and established definitive conclusions on the matter. Substantial delay. EPFO failed to contest the order within timeframes considered reasonable under established legal principles. The court emphasized that such an extensive 5-6 year delay fundamentally undermines judicial finality and creates unacceptable legal uncertainty for all parties. Inadequate justification. When EPFO finally attempted to challenge the tribunal's decision, they provided unconvincing explanations for their extraordinary delay. The court found their justifications lacked credibility and legal merit. Judicial reasoning. The Madras High Court unequivocally dismissed the challenge, invoking the doctrine of laches and principles against unreasonable delay. The court stressed that permitting such significantly delayed challenges would establish dangerous precedent and compromise judicial efficiency. Established precedent. This judgment reinforced the fundamental legal principle that all litigation must proceed with reasonable diligence and promptness. The court affirmed the maxim that excessive delay inherently defeats equitable remedy and erodes rule of law. Broader significance. This ruling serves as a definitive reminder that all statutory bodies, including EPFO, must adhere to reasonable timeframes when challenging adverse decisions, regardless of whether specific statutory limitation periods exist. This landmark decision firmly establishes that even government authorities must respect principles of timely legal action and demonstrates that statutory bodies remain subject to fundamental judicial discipline regarding unreasonable delays. Court allows financially distressed companies to pay EPF damages through manageable installments. The Calcutta High Court's landmark ruling on EPF damages established a crucial precedent balancing statutory compliance with business sustainability. Financial reality recognition. The court acknowledged that sick companies face legitimate financial constraints that make immediate lump sum EPF damage payments potentially devastating to their continued operation. Practical relief mechanism. Rather than demanding immediate full payment, the court mandated reasonable installment plans tailored to each company's financial capacity, while ensuring eventual statutory compliance. Strategic equilibrium. This nuanced approach strikes a balance between recovering mandatory statutory dues and preserving the operational viability of struggling businesses through realistic payment structures. Broader economic protection. The judgment reflects judicial understanding that forcing immediate payments could trigger business closures, resulting in job losses and widespread economic hardship in affected communities. Administrative direction. The ruling clearly establishes that EPF authorities must incorporate a company's documented financial condition when determining enforcement timelines and payment schedules. Rehabilitation-centered interpretation. the court emphasized that labor laws should function as compliance mechanisms that accommodate business recovery, rather than as instruments that precipitate business failure. This significant judicial interpretation demonstrates how courts can apply labor legislation with sensitivity to economic circumstances, while protecting both statutory interests and business sustainability principles. If an allowance is not earned by all employees, it is excluded from the definition of basic wage. Key points regarding basic wage definition and allowances under EPF legislation. Basic wage definition. The core component for EPF calculations, comprising payments made uniformly across the establishment. The Supreme Court has consistently held that basic wage forms the foundation for determining mandatory EPF contributions. Allowance assessment. Determining payment universality requires examining whether an allowance is disbursed to all employees or only to specific categories. This assessment evaluates both the intrinsic nature and distribution pattern of such payments. Exclusion criteria. Non-universal allowances are specifically excluded from EPF calculations as they fall outside the scope of basic wages under Section 2(b) of the EPF Act. Examples include performance incentives, special allowances, and category-specific benefits. Madras HC precedent. The Madras High Court has repeatedly confirmed that selective allowances do not constitute basic wages, establishing that allowances paid based on specific work conditions or to particular employee categories remain exempt from EPF contribution requirements. Exclusion rationale. This principle protects employers from facing disproportionate EPF contribution burdens for specialized payments designed to address specific purposes or to compensate particular employee categories. Documentation imperative. Employers must maintain comprehensive records clearly demonstrating which allowances are selective in nature to substantiate their exclusion from the EPF calculation base. This interpretation finds consistent support across numerous judicial pronouncements, most notably in the landmark Supreme Court judgment in the Bridge and Roof Company case, which established the definitive universality test for determining which allowances fall within the ambit of basic wages. CGIT must consider appeals against damages on merits, even when interest has been deposited. The Karnataka High Court established the landmark precedent regarding EPF damages appeals, providing significant procedural protection for employers. Dispute origin. EPF authority had imposed damages for delayed contribution remittances under Section 14(b) of the EPF Act prior compliance. Employer had already remitted the interest amount under Section 7Q as mandated by authority's legal challenge. Employer subsequently filed an appeal challenging only the damages order before the Central Government Industrial Tribunal, CGIT, procedural barrier. EPF authorities contested the appeal's maintainability, arguing that interest payment constituted acceptance of liability. Judicial clarification. Karnataka HC made a clear distinction between statutory interest and punitive damages under the EPF legal framework principle established. Court definitively held that statutory interest payment does not waive an employer's right to contest punitive damages binding direction. HC explicitly instructed CGIT to adjudicate the appeal based on substantive merits, rather than procedural technicalities. Legal impact. Ruling preserves employers' fundamental right to judicial review, while maintaining compliance with financial obligations. This precedent setting judgment clarifies that compliance with interest payment requirements does not prejudice an employer's statutory right to contest damages before appropriate judicial forums. Conditional stay orders. Distinct from pre-deposit requirements in EPF damages cases, the Madras High Court established a crucial legal distinction that benefits employers contesting EPF damage orders. Key distinction. Court clearly differentiated between conditional stay orders and mandatory pre-deposit requirements. Legal context. Case concerned damages imposed under Section 14(b) of the EPF Act for delayed contributions. Judicial clarification. Conditions attached to stay orders cannot be interpreted as statutory pre-deposit requirements. Procedural significance. Employers no longer required to make specific pre-deposits when seeking stays against damage orders. Reasoned judgment. Court analyzed the distinct legal nature and purpose of stay conditions versus statutory pre-deposits. Immediate relief. Reduces financial burden on employers during the appellate process. Access to justice. Enhances employers' ability to pursue legitimate legal challenges without prohibitive upfront costs. Precedential impact. Ruling likely to influence similar cases under other labor legislation. Balanced approach. Maintains judicial oversight while removing unnecessary procedural barriers to appeals. This landmark ruling streamlines the appellate process for employers challenging EPF damage orders, ensuring procedural fairness while preserving their right to effective judicial review. EPFO authorized to encash demand drafts during appeal period, subject to final outcome for financially distressed establishments. Financial hardship exception. While establishments facing economic difficulties may request special consideration, They cannot evade statutory compliance with recovery proceedings appeal limitations. Ongoing challenges to EPF orders before appellate authorities do not automatically suspend or stay recovery actions' immediate encashment power. EPFO retains legal authority to encash demand drafts during the appeal period to ensure timely collection of statutory contributions. Conditional authority. Bombay High Court ruling. Encashment is permitted with the condition that amounts may be refunded if the appeal ultimately succeeds judicial balancing. Court carefully balances EPFO's statutory mandate to secure employee benefits against the establishment's legitimate right to appeal adverse orders. Legal precedent. This ruling creates binding precedent for similarly situated establishments experiencing financial constraints. While contesting EPF assessment orders' continued obligation, establishments must submit demand drafts even during appeal proceedings, reinforcing the foundational pay now, dispute later principle in Social Security Administration. EPF authority empowered to recover dues immediately upon issuing orders for damages and interest. Immediate recovery power. Gujarat High Court affirmed that EPF authority can initiate recovery proceedings immediately after issuing orders, without any mandatory waiting period. Comprehensive coverage. Authority extends to both damages under Section 14B and interest under Section 7Q of the EPF Act, enabling full financial compliance enforcement. No statutory stay. Unlike other administrative proceedings, the EPF Act contains no mandatory cooling period between order issuance and recovery action commencement. Judicial endorsement. Multiple high courts have consistently upheld this immediate recovery power, establishing robust jurisprudence supporting the EPF authority's enforcement actions. Enforcement arsenal. Recovery mechanisms available to the authority include bank account attachments, property seizures, and third-party recovery notices to ensure effective compliance. Constitutional validation. The Supreme Court has affirmed the constitutional legitimacy of these immediate recovery provisions as essential safeguards for Social Security protection. No employer-employee relationship exists even when contractor's worker is consistently posted with a single principal employer. Contractor autonomy. When a contractor maintains supervisory control over work assignments, leave approvals, and salary disbursements, the worker remains the contractor's employee regardless of placement location. Long-term assignments. Even when workers are deployed at various locations under a single principal employer for extended periods, sometimes years, at the same company's different sites, the contractual relationship persists. Legal distinction. Courts have examined whether such long-term placements transform into direct employment relationships, establishing important precedents for contract labor arrangements. Supreme Court clarification. The highest court has ruled that multiple postings under a single employer do not establish an employer-employee relationship, provided the contractor maintains effective control over employment terms. Determining factors. Courts evaluate who disburses salary, approves leave, exercises disciplinary authority, and maintains employment records to determine the true employer. Business implications. Organizations can engage contract workers long-term without creating direct employment obligations if proper contractor management frameworks are maintained. Compliance requirements. Maintaining comprehensive documentation demonstrating the contractor's supervisory and administrative control is essential for legal protection. Adducing of evidence by management and inquiry not required when workman admits guilt. Legal principle. The Madras High Court established that when a workman admits guilt during a disciplinary proceeding, management is relieved of the obligation to produce additional evidence. This landmark ruling streamlines the disciplinary process in cases of admitted misconduct, enabling employers to proceed with appropriate disciplinary action without conducting extensive evidentiary proceedings. Case background. The court emphasized that a detailed inquiry becomes unnecessary and redundant when an employee has voluntarily acknowledged their misconduct. Procedural efficiency. The judgment recognizes that requiring management to present evidence, despite a clear admission, would impose unnecessary procedural hurdles and administrative burdens on employers. Balance of interests. While safeguarding workers' rights remains paramount, the court acknowledged that justice is equally served when disciplinary actions can proceed efficiently following voluntary admissions of misconduct. Legal threshold. For this exemption from standard evidentiary requirements to apply, the admission must be clear, unambiguous, voluntary, and demonstrably free from any form of coercion or duress. Sundays and paid holidays count toward 240 days of continuous service calculation. In a significant ruling, the Rajasthan High Court established these important principles. Continuous service calculation. The court provided definitive guidance on calculating the mandatory 240 days of continuous service under Section 25B of the Industrial Disputes Act 1947, resolving a long-standing ambiguity in labor law interpretation. Inclusion of Sundays. Weekly off days, Sundays, must be counted within the 240-day requirement. despite employees not performing work duties on these days. This acknowledges that the employment relationship remains intact during scheduled rest periods, inclusion of paid holidays, all paid holidays for, including national holidays, festivals, and other holidays declared under the Factories Act or Negotiable Instruments Act 4 must be incorporated into the continuous service calculation. Enhanced worker protections. This inclusive interpretation substantially strengthens worker protections by creating a more accessible pathway to meet the continuous service threshold necessary for various employment benefits and legal safeguards. Judicial precedent. This landmark judgment establishes a binding precedent for labor courts and industrial tribunals throughout India when assessing employee eligibility for service length-based benefits and protections. Retrenchment applications. This calculation method proves especially critical in retrenchment scenarios, where employees must establish continuous service to qualify for compensation and related benefits. The court emphasized that this inclusive approach faithfully reflects the protective intent of labor legislation, ensuring that overly technical interpretations do not unfairly deprive workers of their statutory entitlements. Resignation of an employee cannot be accepted retrospectively. This fundamental employment law principle was established by the Punjab and Haryana High Court in a landmark judgment that strengthens worker protections. Legal principle. The Punjab and Haryana High Court ruled that employers cannot backdate their acceptance of an employee's resignation, preventing retroactive termination of employment relationships. Case background. The judgment stemmed from a case where an employer attempted to accept a resignation letter with backdated effect, which would have reduced the employee's documented service period and corresponding benefits. Employee protection. This ruling shields employees from potential manipulation of resignation dates that could diminish their benefits and entitlements, ensuring employers cannot arbitrarily shorten an employee's tenure through backdating. Effective date. A resignation can only take effect from the date it is formally accepted, not from any earlier date, meaning the employment relationship continues until proper acceptance occurs. Service calculations. The time between submission of resignation and its formal acceptance must be counted as active service for all employment-related benefits and calculations. Practical implications. Employers must maintain meticulous documentation and process resignations promptly to avoid legal complications, including properly date stamping all resignation-related communications. Procedural requirements. Organizations need clear, established protocols for handling resignations, including formal acknowledgement of receipt and transparent acceptance procedures. Judicial reasoning. The court concluded that permitting retrospective acceptance would create opportunities for exploitation and undermine the employment security guarantees enshrined in law. This significant ruling reinforces the necessity of procedural fairness in employer-employee relationships and upholds the broader principles of employment security in Indian labor law. Increase in minimum wages by 25% after 10 years cannot be considered excessive. Time period analysis. The 25% increase implemented after a full decade represents a significantly lower rate than the cumulative inflation during the same period. Annual growth rate. This increase translates to merely 2.5% per annum, substantially below the average annual cost of living adjustments experienced by workers. Judicial determination. The Madhya Pradesh High Court definitively ruled that this increase falls within reasonable parameters considering relevant economic indicators and time span. Legal reasoning. The court emphasized that the increase aligns with the fundamental purpose of minimum wage legislation to protect workers' basic standard of living. Economic justification. Court analysis revealed that essential commodity prices and overall living costs had escalated by a considerably higher percentage than 25% during the same decade. Legal precedent. This landmark judgment establishes a crucial benchmark for assessing the reasonableness of minimum wage adjustments implemented after extended intervals. Socioeconomic impact. The court acknowledged that despite this increase, minimum wage earners continued to face significant financial challenges in meeting basic needs. Employer objections. Corporate contentions regarding potential financial hardships were dismissed as unsupported by evidence, particularly given the modest effective annual increase rate. ESIC cannot assess contributions under heads of accounts absent from the original show cause notice. Show cause notice limitation. ESIC must specify all relevant heads of accounts for contribution assessment in their initial notice. Procedural violation, including additional heads in the assessment order that weren't mentioned in the original notice, constitutes improper procedure. Legal challenge basis. Employers have successfully contested assessments that incorporated new heads not specified in the original notice. Bombay High Court precedent. The court definitively ruled that ESIC lacks authority to assess contributions under heads omitted from the show cause notice. ESIC jurisdiction. While the Employee State Insurance Corporation has statutory authority to collect contributions, this authority is bound by procedural requirements. Natural justice principle. The ruling reinforces that administrative bodies must follow fair procedure, giving proper notice before imposing financial obligations. Assessment boundaries. Contribution assessments must remain strictly confined to the specific heads of accounts explicitly mentioned in the initial notice. Employer safeguards. This ruling protects employers from unexpected liability expansion during ongoing assessment proceedings. Proper amendment process. If ESIC wishes to include additional heads, it must issue a fresh or appropriately amended show cause notice. Precedential impact. This decision establishes important guidelines for procedural compliance by all statutory bodies conducting financial assessments. Canteen workers are not employees of the management for the purposes of payment of gratuity. Legal classification. Staff working in company canteens are not considered direct employees of the main establishment for gratuity benefit purposes. Contractual relationship. Canteen workers typically operate under separate contractual arrangements with third-party service providers or contractors. Gratuity entitlement. These workers do not qualify for gratuity payments from the main establishment as they fall outside the statutory definition of employee. Judicial precedent. The Chhattisgarh High Court confirmed this distinction, establishing that no primary employer-employee relationship exists with the main establishment control test. The court determined that lack of direct control over hiring, firing, and daily operations by the main establishment disqualifies canteen workers from gratuity claims. Financial responsibility. The contractor, or third-party agency directly employing these workers bears the legal obligation for their gratuity payments. Broader impact. This ruling strengthens the legal distinction between direct employment and service arrangements when determining statutory benefit eligibility across industries.
Accident insurance policy obtained for one unit would not extend to employees at another unit. Insurance coverage limitation. The Bombay High Court has ruled that accident insurance policies are strictly unit-specific and cannot automatically extend to other units of the same company. This landmark decision underscores the critical necessity of securing separate insurance coverage for each operational unit to ensure comprehensive employee protection. Legal precedent. The court's judgment firmly establishes that each operating location must be individually specified and covered in insurance documentation for claims to be valid. Risk management. Organizations operating multiple branches or manufacturing facilities must thoroughly audit their insurance portfolios to identify and address potential coverage gaps. Compliance requirement. Human resources departments are obligated to maintain discrete policy registrations for different geographical locations and operational units. Financial implications. Inadequate unit-specific coverage may expose companies to substantial uninsured liabilities in the event of workplace accidents. Documentation importance. Employment contracts should explicitly specify which insurance policies cover employees based on their designated work location. Employers cannot be compelled to pay wages beyond an employee's retirement age. Supreme Court ruling. India's apex court has definitively established that employers cannot be directed to pay wages after an employee reaches their stipulated retirement age. Compensation limitation. The judgment clarifies that even in cases of wrongful termination or ongoing labor disputes, wage compensation must terminate upon reaching the prescribed retirement age. Remedial alternatives. While continued wage payment beyond retirement is impermissible, courts may award other appropriate forms of compensation to address workplace injustices. Judicial precedent. This landmark ruling creates a significant benchmark for remedies in employment disputes, particularly in cases involving reinstatement claims. Economic implications. This judgment enables organizations to more accurately forecast their maximum financial exposure in wrongful termination litigation by establishing a clear temporal ceiling. Adjudicatory guidance. Labor courts and industrial tribunals must now factor in retirement age as a definitive endpoint when calculating back wages or determining appropriate compensation packages. Strategic considerations for employees. Workers engaged in extended employment disputes should proactively consider retirement age limitations when formulating their legal strategies and remedial expectations. This watershed judgment establishes crucial temporal boundaries for employer liability, while effectively balancing organizational financial interests against employees' rights to fair compensation in workplace disputes. Passing comments about a female employee's hair does not constitute sexual harassment when relations were cordial. Legal question: whether remarks about a female employee's hair constitute sexual harassment under the Sexual Harassment of Women at Workplace Act, 2013. Contextual background. The workplace environment featured previously cordial relations between parties where casual remarks were occasionally exchanged without prior objection. Judicial authority. The Bombay High Court delivered this landmark ruling in a significant workplace harassment case. Key finding: such comments do not amount to sexual harassment when workplace relations were demonstrably cordial, and malicious intent could not be established. Judicial reasoning: the court distinguished isolated remarks about physical appearance without sexual overtones from genuine cases of harassment that create hostile environments. Critical factors: the overall workplace relationship and specific context of the comments were determinative in assessing the nature of the interaction. Evidentiary threshold: the court required clear demonstration of a hostile work environment or established pattern of offensive behavior. Guiding principle: not all uncomfortable workplace interactions qualify as harassment. Both objective circumstances and subjective perceptions must be balanced in assessment. Workplace implications: while employers should maintain clear communication guidelines, courts must carefully evaluate contextual factors when adjudicating harassment claims. Fixation of different minimum wage rates across localities is not mandatory. Under law legal interpretation, the Madhya Pradesh High Court has definitively ruled that labor authorities are not legally obligated to establish varying minimum wage rates for different geographical regions. While the Minimum Wages Act permits geographical differentiation in wage rates, such differentiation is discretionary rather than mandatory. This interpretation grants necessary flexibility to labor authorities in wage administration while ensuring adequate minimum standards across all regions. The court reaffirmed that the primary objective of the Minimum Wages Act is to safeguard workers' interests by guaranteeing fair compensation. Employers must adhere to established minimum wage standards irrespective of their locality within the jurisdiction. This balanced interpretation promotes administrative efficiency while upholding the fundamental purpose of minimum wage legislation. The judgment clarifies that implementing a uniform minimum wage across different geographical areas remains fully compliant with statutory provisions. This significant ruling establishes that while regional economic variations may be considered in wage determinations, labor authorities maintain legitimate discretion in implementing minimum wage structures. The court's interpretation facilitates more streamlined wage enforcement mechanisms, while simultaneously preserving workers' fundamental rights to equitable compensation regardless of their geographical location. Claims related to gratuity cannot be adjudicated before the authorities under the ID Act. The legal framework for employee gratuity claims establishes clear jurisdictional boundaries that employers and employees must respect when addressing such matters. Gratuity definition: a statutory benefit provided to employees upon retirement or resignation after completing at least 5 years of continuous service, calculated based on final salary and tenure. Jurisdictional boundary: Industrial Disputes Act authorities lack jurisdiction over gratuity matters, as these are governed by specialized legislation with dedicated resolution mechanisms. Appropriate forum: gratuity claims must be filed with the controlling authority appointed under the Payment of Gratuity Act, with subsequent appeals directed to the designated appellate authority. Judicial precedent: the Madras High Court has affirmed that separate adjudication pathways exist for gratuity disputes, emphasizing that labor courts and industrial tribunals cannot entertain these specialized claims. Legal foundation: this jurisdictional separation ensures expert handling of gratuity matters while preventing conflicting decisions that could arise from parallel proceedings or forum shopping. Navigating these jurisdictional distinctions is essential for proper compliance and effective resolution when pursuing gratuity-related claims within India's legal framework. High Court can restrict outsiders from entering the premises of the establishment during a strike. Key aspects of this established legal principle: strike situation: during legitimate industrial action, workers exercise their statutory collective bargaining rights while protesting against working conditions or management decisions, creating a potentially volatile environment. Judicial authority: the Calcutta High Court has affirmed its jurisdiction to maintain public order during labor disputes, carefully balancing the constitutional right to strike against the imperative to protect property and prevent unlawful assembly entry restrictions. Courts may impose specifically tailored limitations on non-employee access to prevent escalation of tensions, deter potential violence, and mitigate security risks during ongoing industrial disputes. Legal foundation: this principle stems from the court's inherent powers to issue injunctive relief, where necessary, to prevent public disorder, protect property rights, and maintain industrial peace. Rights equilibrium: judicial intervention seeks to preserve workers' legitimate protest rights, while simultaneously safeguarding the establishment's business continuity and asset security. Restriction parameters: court orders must precisely define which categories of individuals are prohibited from entry, the geographical boundaries of restriction, and the specific duration of such limitations' constitutional compliance. These judicial restrictions have been consistently upheld as reasonable, proportionate limitations that balance competing interests without fundamentally impairing the right to peaceful protest. No interest is to be levied on delayed payment of gratuity. When it was held up due to audit objection, the Orissa High Court established a significant precedent regarding gratuity payment delays, where legitimate administrative procedures cause postponement. Gratuity payment delay. Retirement benefits were disbursed beyond the statutory timeframe mandated under the Payment of Gratuity Act 1972. Reason for delay. Payment was withheld pending resolution of legitimate audit objections that necessitated thorough verification. Interest question. The court addressed whether statutory interest penalties should apply as typically mandated in cases of unjustified payment delays. Audit process. Financial auditors raised substantive concerns requiring proper investigation and documentation before funds could be released. Administrative review. The time required for internal verification and resolution of audit concerns was deemed reasonable and necessary. Legal principle. Delays arising from adherence to established financial oversight protocols do not constitute willful or malicious withholding of benefits. Orissa HC ruling. The court determined that no interest penalty should be imposed when delays result from genuine audit objections requiring proper resolution. This landmark judgment carefully balances an employee's right to prompt payment of retirement benefits against an organization's responsibility to maintain financial integrity and accountability in the disbursement of gratuity payments. Inquiry hurriedly conducted in a single day deemed legally invalid. The Madras High Court established a significant precedent regarding expedited disciplinary proceedings. Disciplinary notice. Charge sheet issued to employee without affording adequate time for formulating a response or preparing a comprehensive defense. Single-day inquiry. Entire disciplinary proceeding hastily compressed into one day, effectively denying the employee reasonable opportunity to present their case fully. Procedural violations. Court identified multiple procedural deficiencies, including insufficient time for thorough document examination and proper witness cross-examination. Principles of natural justice. Court emphatically held that such precipitous proceedings fundamentally violate established principles of natural justice and the right to fair hearing. Legal challenge. Employee successfully contested the validity of the expedited proceeding through appropriate judicial channels. Madras HC ruling. Court unequivocally declared such rushed inquiries legally untenable and procedurally improper, establishing a binding precedent for similar cases. Remedy mandated. Court directed the employer to conduct a fresh inquiry with sufficient time allocation and proper implementation of procedural safeguards. Legal implications. This landmark ruling reinforces that disciplinary proceedings must provide genuine opportunity for defense regardless of the severity or nature of allegations. This decision underscores the judiciary's commitment to ensuring procedural fairness in employment disciplinary matters and prohibits employers from circumventing due process through artificially accelerated proceedings. Appeal under standing orders against termination is not necessary before approaching statutory authorities. The Orissa High Court ruling on employee termination procedures establishes an important precedent for labor dispute resolution. Legal question. Whether employees must exhaust internal appeal mechanisms before accessing statutory remedies. Case background. Terminated employee directly approached labor authorities without first pursuing internal appeals specified in company standing orders. Employer's contention. Application was premature as internal remedies had not been exhausted. Orissa HC ruling. Employees need not file appeals under standing orders before approaching statutory labor authorities. Legal reasoning. Statutory remedies operate independently of and parallel to internal mechanisms provided in standing orders. Direct access affirmed. Terminated employees may directly approach statutory authorities without first exhausting company appeal processes. Procedural benefit. Ruling streamlines dispute resolution by removing procedural barriers for terminated employees. Broader significance. Judgment enhances employee access to justice and prevents undue delays in termination disputes. Legal precedent. Decision provides persuasive authority across jurisdictions supporting direct access to statutory remedies. This landmark ruling clarifies that internal appeal mechanisms cannot be imposed as mandatory prerequisites to accessing statutory protections under labor laws. Application for condonation of delay is not mandatory before payment of wages. Authority. Key points regarding condonation of delay in wage claims. Delayed claims. Applications filed beyond the statutory limitation period of 12 months from when wages became due under the Payment of Wages Act. Condonation application. Formal petitions seeking excuse for delay in filing wage claims, typically explaining reasons for late submission. Procedural question. Whether a separate application for condonation is mandatory before the authority can hear the substantive wage claim. Himachal Pradesh High Court ruling. the court clarified that a separate formal application is not mandatory. The authority can directly condone delay when sufficient cause is demonstrated. Statutory foundation. Section 15(2) of the Payment of Wages Act confers discretionary power on the authority to excuse reasonable delays. Practical benefit, eliminates unnecessary procedural formalities for wage claimants, particularly beneficial for workers with limited legal resources. Evidential requirement, claimant must still substantiate valid reasons for delay within the main application itself. Judicial philosophy, court emphasized the welfare nature of labor legislation, prioritizing substantive justice over procedural technicalities. This significant ruling streamlines access to justice for workers pursuing delayed wage claims, balancing worker protection with judicial discretion. The decision upholds the pro-worker spirit of labor legislation, while maintaining the authority's power to reject unjustified delays, creating a more efficient dispute resolution mechanism. Government cannot pass interim orders after a dispute has been referred to the labor court. Critical aspects of this jurisdictional limitation: industrial dispute, formal conflict between employers and employees regarding employment terms, working conditions, or management decisions that substantially affect workers' interests. Referral process. When conciliation fails, government formally transfers the matter to labor court for adjudication under Section 10 of the Industrial Disputes Act. Jurisdictional transfer. Upon referral, authority completely shifts from the executive branch to the labor court, establishing exclusive judicial jurisdiction. Government restraint. Karnataka High Court ruling, government lacks authority to issue interim directives after referral, as this constitutes improper interference with judicial proceedings. Prohibition on parallel authority, government cannot exercise concurrent powers over matters already under labor court consideration. Constitutional foundation, this limitation stems from fundamental principles of jurisdictional exclusivity and the constitutional separation of powers between executive and judiciary. Procedural consequence, parties must petition the labor court directly for any interim relief through appropriate legal applications, rather than reverting to government authorities. This judicial principle ensures clear boundaries between governmental and judicial functions, preventing contradictory directives and maintaining the integrity of industrial dispute resolution mechanisms. EPFO claims beyond 3 years are barred if they cause irretrievable prejudice to establishments. Legal precedents have established clear limitations on EPFO's authority to pursue historical claims. Limitation period. The Meghalaya High Court established an effective 3-year limitation for EPFO claims, derived from principles of natural justice and Article 14 of the Constitution. Judicial precedent, courts have firmly established that unlimited retrospective claims violate fundamental legal principles of finality and certainty. Prejudice assessment, claims beyond 3 years must be evaluated based on potential irretrievable prejudice to the establishment, considering absence of relevant records and documentation, intervening changes in management or ownership, severe financial impact on current business operations. Legal protection, establishments receive complete protection from stale claims that would cause substantial operational or financial harm, especially when compliance mechanisms have been subsequently implemented. Balanced approach, courts must carefully balance employee welfare against the establishment's sustainability and continued viability. Evidentiary requirements, establishments must substantiate prejudice claims with concrete evidence demonstrating specific harm resulting from delayed proceedings. This limitation safeguards businesses that operated in good faith, according to their understanding of applicable law, preventing retroactive enforcement that could destabilize otherwise compliant establishments. Section 7A orders must be based on concrete evidence, not mere suspicion or doubt about an establishment's position. The Madras High Court has established a significant legal precedent by ruling that EPF authorities cannot pass Section 7A orders based solely on suspicion or doubt regarding an establishment's compliance status. Evidentiary standard, orders must be founded on substantive evidence and thorough assessment rather than conjecture or presumption of non-compliance. Burden of proof, the court explicitly placed the onus on EPF authorities to demonstrate non-compliance through verifiable evidence before issuing demands. Procedural fairness, all Section 7A proceedings must strictly adhere to principles of natural justice, ensuring a fair and impartial hearing for the establishment. Judicial scrutiny, orders passed without sufficient supporting evidence are vulnerable to being overturned upon judicial review. Protection against arbitrariness, this landmark ruling shields establishments from arbitrary assessments and financially burdensome demands that lack evidential foundation. Compliance documentation, employers should maintain comprehensive and organized records to effectively refute any unsupported allegations during Section 7A inquiries. Persons employed for short period due to passing necessity are not employees under EPF Act. According to the landmark judgment by the Andhra Pradesh High Court, temporary employment, workers engaged for a limited duration to complete specific tasks without any expectation of continued employment are exempt from EPF provisions. Passing necessity, employment arising from seasonal demands, special projects, or unexpected business circumstances that fall outside regular operational requirements. Legal classification, such workers do not qualify as employees under the EPF Act, as the statutory definition primarily encompasses regular, continuous employment relationships. Contribution exemption, employers are not required to make EPF contributions for temporary workers, significantly reducing administrative and financial obligations. Assessment criteria. The court established that the nature, duration, and purpose of employment are critical factors in determining EPF applicability. Documentation requirements. Establishments must maintain comprehensive records to substantiate the temporary nature of employment if challenged by EPF authorities. Industry impact. This ruling provides essential clarity for sectors with seasonal or project-based workforce needs, including construction, agriculture, event management, and similar industries. This judicial interpretation creates a clear distinction between regular employees and temporary workers, offering significant compliance guidance for businesses managing diverse workforce arrangements. No interest or damages when the establishment deposits contribution under Section 7A. Timely compliance with EPF contribution requirements following official assessments carry significant financial and legal implications for employers. Section 7A assessment. The EPF authority examines payroll records and documentation to determine the precise contribution amount due from an establishment, constituting an official determination process. 1. Timely payment. When an establishment remits the full assessed amount within the stipulated deadline, typically 15 days from the order date, it satisfies its statutory obligation under the EPF Act. 2. Penalty exemption. Employers meeting these payment deadlines are legally shielded from additional interest charges under Section 7Q and damages under Section 14B, potentially saving substantial amounts that would otherwise accumulate over time. 3. Judicial precedent. The Madras High Court has explicitly confirmed this protection, establishing that punitive measures cannot be imposed on employers demonstrating prompt compliance with Section 7A assessment orders. 4. Documentation practices. Establishments should maintain comprehensive records of assessment notices and payment confirmations to effectively demonstrate timeline adherence during potential disputes or regulatory audits. 5. Equitable treatment. This legal position appropriately distinguishes between employers who demonstrate good faith compliance and those who deliberately evade or delay their contribution obligations. 6. This principle effectively balances employee benefit protection with reasonable safeguards for employers who promptly fulfill their obligations following official assessments. Composite order passed under Sections 14B and 7Q is appealable. The Karnataka High Court has delivered a significant clarification regarding the appeal process for combined EPF enforcement orders. Composite order definition. The Karnataka High Court specifically addressed enforcement orders that simultaneously impose both damages under Section 14B and interest under Section 7Q of the EPF Act. 1. Complete appealability. Such combined orders are fully appealable in their entirety, establishing an important exception to the general rule that Section 7Q interest orders, when issued independently, cannot be appealed to. Procedural streamlining. This ruling establishes a coherent judicial pathway for employers to challenge both the punitive and compensatory elements when they appear within a unified enforcement action. 3. Legal justification. The court reasoned that bifurcating these interconnected components would create unnecessary procedural complexity and risk contradictory judicial outcomes across different forums. 4. Practical benefits. Employers confronting such composite orders now benefit from a consolidated appellate mechanism, eliminating the need for parallel proceedings and potentially inconsistent litigation strategies. 5. This benchmark judicial interpretation effectively harmonizes procedural efficiency with substantive rights protection. By recognizing the practical realities of EPF enforcement actions, the court has created a more navigable legal framework that preserves the distinct statutory purposes of penalty and interest provisions while acknowledging their operational overlap in compliance proceedings. HC can permit EPF damage appeals beyond limitation period. With monthly interest deposits, the Madras High Court established a significant exception to limitation periods for EPF damage order appeals. Limitation period exception. Appeals against EPF damage orders may be permitted after the statutory limitation period has expired, provided appellants demonstrate legitimate reasons for delay. Conditional relief. Appellants must make monthly deposits of the interest amount as directed by the court, ensuring financial compliance during the appeal process. Balancing approach. The ruling balances enforcement of timely appeals with providing relief in deserving cases, acknowledging that strict adherence to limitation periods can sometimes lead to injustice. Financial protection. Monthly deposit requirements safeguard the EPF organization's interests during appeals, preventing the use of appeals as delay tactics. Judicial discretion. The relief stems from the High Court's inherent powers to prevent miscarriage of justice in exceptional circumstances. Merit-based evaluation. Each delay condonation application is assessed individually, considering the reason for delay, prima facie case strength, and the appellant's conduct. Precedential value. This judgment establishes an important precedent for other high courts when considering similar EPF damage order appeals. Practical impact. Employers now have a potential pathway to challenge EPF damage orders beyond the limitation period by demonstrating sufficient grounds and complying with interim deposit requirements. This landmark ruling reflects the judiciary's effort to balance procedural requirements with substantive justice, providing flexibility while maintaining the integrity of the EPF compliance system.
आज हम हिंदुस्तानी लेबर कानून के कुछ बहुत ही अहम अदालती फैसलों पर बात कर रहे हैं।
जी हाँ, ये वो फैसले हैं जिन्होंने आजरों और मुलाजमीन दोनों के लिए चीजों को काफी बदला है। हुकूक, फराइज, इन सब की नई तारीफ हुई है।
बिल्कुल, और हमारी ये सारी मालूमात मुख्तलिफ हाई कोर्ट्स और सुप्रीम कोर्ट के फैसलों, उन पर मबनी दस्तावेजात, गाइड्स, सवाल जवाब, इन सब से ली गई हैं।
मकसद यही है कि जो किलीदी फैसले हैं ईपीएफ पर, उजरत, ग्रेजुएटी, मुलाजमत से निकालने के मामलात, उनको समझा जाए।
हाँ, उन पर जो असर पड़ा है उसको समझना। अच्छा, एक दिलचस्प बात से शुरू करते हैं।
जरूर।
आपको पता है कि किसी मुलाजिम का इस्तीफा पिछली यानी गुजरी हुई तारीख से कबूल नहीं किया जा सकता?
जी, ये एक अहम नुक्ता है।
तो चलें इसी तरह के और नुकात पर बात करते हैं।
इसका जायजा लेते हैं।
ठीक है, ईपीएफ के मामलात से शुरू करें। वहाँ काफी पेचीदगियां हैं।
हाँ बिल्कुल, जैसे पंजाब और हरियाणा हाई कोर्ट का वो फैसला कि अगर सेक्शन 7A के तहत ईपीएफ का कोई हुक्म आया है और उस पर कोर्ट का स्टे ऑर्डर है तो ट्रायल कोर्ट कार्रवाई नहीं कर सकती। इसका मतलब क्या हुआ अमली तौर पर? मतलब
ये कि आजर को एक तरह का तहफ्फुज मिल जाता है जब तक वो मुतनाज़ा ईपीएफ असेसमेंट का मामला चल रहा है। स्टे है तो सब रुका रहेगा।
अच्छा।
इसी तरह मेघालय हाई कोर्ट ने भी एक अहम बात कही है कि अगर ईपीएफ अथॉरिटी अपने दायरा इख्तियार से, मतलब पावर से बाहर जाकर या गलत इस्तेमाल करके सेक्शन 14B का हुक्म दे, जिसमें हर्जाना वगैरह लगता है,
हाँ, जो जुर्माने लगते हैं,
जी, तो उस हुक्म के खिलाफ भी रिट पिटिशन दायर की जा सकती है, यानी आप हाई कोर्ट जा सकते हैं।
ये तो इंतजामिया को जवाबदाह बनाने वाली बात हुई।
बिल्कुल, और कलकत्ता हाई कोर्ट ने तो ईपीएफओ पर ये लाजिम कर दिया है कि वो जो हर्जाने यानी डैमेजेस का हिसाब लगाते हैं ना, उसकी पूरी वजाहत दें, तरीका बताएं कि कैसे हिसाब लगाया।
सिर्फ रकम बता देना काफी नहीं।
जी नहीं, पूरा हिसाब किताब समझाना होगा। इससे शफाफियत आएगी। शफाफियत की बात आई है तो उजरत और ईपीएफ के हिसाब में भी एक अहम नुक्ता है। मद्रास हाई कोर्ट और सुप्रीम कोर्ट का फैसला है कि अगर कोई अलाउंस, कोई भी भत्ता तमाम मुलाजमीन को एक जैसा नहीं मिलता,
हाँ,
तो उसे ईपीएफ के लिए बुनियादी उजरत यानी बेसिक वेज का हिस्सा नहीं माना जाएगा।
जी हाँ, इसे कहते हैं यूनिवर्सैलिटी टेस्ट। मतलब क्या ये अलाउंस यूनिवर्सल है, सबके लिए है? अगर नहीं तो वो बुनियादी उजरत में शुमार नहीं होगा।
ये तो बुनियादी उजरत की तारीफ को बहुत वाज़ेह करता है।
बिल्कुल, और देखें अदालतें कितनी हकीकत पसंद भी हो रही हैं। कलकत्ता हाई कोर्ट ने ही माली मुश्किलात में घिरी कंपनियों को ईपीएफ के हर्जाने किस्तों में अदा करने की इजाजत दे दी।
अच्छा, ये तो बड़ी बात है।
जी, ये कारोबारी मुश्किलात को तस्लीम करने वाली बात है।
और ग्रेजुएटी के हवाले से कुछ?
हाँ, ओडिशा हाई कोर्ट का एक फैसला है कि अगर ग्रेजुएटी देने में देर इस वजह से हुई कि कोई जायज ऑडिट का एतराज था तो फिर उस ताखीर पर सूद नहीं देना पड़ेगा।
यानी अगर वजह ठोस थी तो सूद माफ। ये भी एक अमली बात है।
जी।
अच्छा, मुलाजमत के ताल्लुकात में भी कुछ बड़ी दिलचस्प वजाहतें हुई हैं। एक तो सुप्रीम कोर्ट ने कहा कि अगर कोई ठेकेदार का कारकुन है और वो लंबे अरसे से एक ही प्रिंसिपल आजर के पास काम कर रहा है,
हाँ, ये बहुत आम सूरत हाल है,
तो भी जरूरी नहीं कि वो खुद ब खुद उस प्रिंसिपल आजर का मुलाजिम बन जाए।
इसमें जो किलीदी चीज है ना, वो कंट्रोल टेस्ट है। यानी रोजमर्रा के काम पर, शराइत पर, निगरानी पर असल कंट्रोल किसका है, ठेकेदार का या प्रिंसिपल आजर का?
अच्छा,
अगर कंट्रोल ठेकेदार का ज्यादा है तो सिर्फ लंबी मुद्दत काम करने से वो प्रिंसिपल आजर का मुलाजिम नहीं बन जाता।
ये तो बहुत से कॉन्ट्रैक्ट वर्कर्स के लिए जानना जरूरी होगा।
बिल्कुल।
और वो इस्तीफा वाली बात जो हमने शुरू में कही थी, पंजाब और हरियाणा हाईकोर्ट ने साफ कहा कि इस्तीफा माजी की तारीख से कबूल नहीं हो सकता, बैक डेट नहीं कर सकते।
जी, इससे गलत इस्तेमाल रुकता है और तरीकेकार की अहमियत एक और फैसले से भी जाहिर होती है। मद्रास हाईकोर्ट ने कहा कि अगर किसी मुलाजिम के खिलाफ कोई इंक्वायरी हो रही है
हाँ,
और वो एक ही दिन में जल्दी जल्दी निपटा दी जाए तो वो कानूनी तौर पर ठीक नहीं मानी जाएगी। मतलब मुनासिब वक्त देना जरूरी है।
मुनसिफाना अमल, फेयर प्रोसीजर बहुत जरूरी है।
बिल्कुल।
और एक और अहम फैसला राजस्थान हाई कोर्ट का था, 240 दिन की सर्विस के हिसाब से मुताल्लिक।
हाँ, वो 240 दिन वाली शर्त बहुत सी चीजों के लिए अहम है।
जी, तो अदालत ने कहा कि ये 240 दिन गिनते वक्त जो हफ्तावार छुट्टियां होती हैं जैसे इतवार, और जो दूसरी बामुआवजा छुट्टियां हैं उनको भी शुमार किया जाएगा।
जी हाँ, ये हिसाब किताब मुलाजमीन के लिए जो कानूनी फवायद हैं जैसे रिट्रेंचमेंट कंपनसेशन वगैरह, उनके लिए बहुत अहम है। इस वजाहत से मुलाजमीन के हुकूक को तहफ़्फ़ुज़ मिलता है।
आखिर में ESIC यानी एम्प्लॉइज स्टेट इंश्योरेंस कॉरपोरेशन, इसके हवाले से भी दो मुख्तलिफ नुकात हैं।
जी बताइए।
पहला, बम्बई हाईकोर्ट का फैसला कि ESIC उन चीजों पर शिराकत यानी कंट्रीब्यूशन का अंदाजा नहीं लगा सकता जो उन्होंने अपने पहले वजह बताओ नोटिस, शो कॉज नोटिस में शामिल ही नहीं की थी।
अच्छा, यानी जो इल्जाम शुरू में लगाया ही नहीं उस पर बाद में कार्रवाई नहीं कर सकते। ये फिर वही बात हुई, तरीक़ेकार की पाबंदी।
बिल्कुल, शुरू में ही सब कुछ वाजे करना होगा।
जी, और दूसरा नुक्ता
भी बॉम्बे हाई कोर्ट का ही है, लेकिन थोड़ा मुख्तलिफ है। अदालत ने एक केस में कहा कि अगर काम की जगह पर लोगों के आपस के ताल्लुकात उमूमन अच्छे थे, दोस्ताना थे, तो किसी खातून मुलाजमा के बालों पर किया गया कोई तबसरा जरूरी नहीं कि जिनसी हरासमाइती हो।
ओह, तो मतलब सियाक़ो सबाक़ बहुत अहम है।
हाँ, ऐसा लगता है।
जी, ये फैसला यही दिखाता है कि हरासा के जो दावे हैं उनका जायजा लेते वक्त पूरे पसे मंजर को देखना होगा। नीयत क्या थी, माहौल कैसा था, ताल्लुकात कैसे थे। हर नागवार बात खुद ब खुद कानून की नजर में जिनसी हरासमाइती नहीं बन जाती।
सही। तो अगर हम इस सब का खुलासा करें, ये अदालती फैसले हिंदुस्तान में जो काम का माहौल है, वर्क प्लेस है, उसे मुसलसल बदल रहे हैं, नई शक्ल दे रहे हैं।
जी हाँ, EPF के हिसाब से लेकर नौकरी से निकालने के तरीक़ेकार तक हर चीज पर इनका गहरा असर पड़ रहा है।
तो आजरों और मुलाजमीन दोनों के लिए बहुत जरूरी है कि वो इन तब्दीलियों से, इन फैसलों से बाखबर रहें।
इसमें एक दिलचस्प पहलू ये भी है कि अदलिया कैसे कोशिश कर रही है कि कानून की जो ज़रूरियात हैं और जो माशी हकीकतें हैं और जो क़दरती इंसाफ के उसूल हैं उनमें एक तवाज़ुन पैदा किया जाए।
हाँ, ये सिर्फ कानूनी नुकात नहीं है।
नहीं, बिल्कुल नहीं। ये काम की जगह पर जो रिश्ते बदल रहे हैं, जो तवक्कुआत बदल रही हैं, उनकी अक्कासी भी करते हैं और ख़ास तौर पर शफाफियत पर, मुनसिफाना अमल पर जोर बढ़ता जा रहा है।
इन सारे फैसलों में हमने देखा तरीकाकार की शफाफियत और सियाक़ो सबाक़, इन दो चीजों पे बार बार जोर आया है।
जी बिल्कुल।
तो अब आखिर में एक सवाल सोचने के लिए, मुस्तकबिल में टेक्नोलॉजी जैसे HR में अब मसनूई ज़हानत यानी AI का इस्तेमाल बढ़ रहा है।
हाँ, ये तो बहुत बड़ा मौजू है।
तो ये टेक्नोलॉजी हिंदुस्तानी काम की जगह पर उन कायम शुदा कानूनी उसूलों को जो शफाफियत और सियाक़ो सबाक़ पर जोर देते हैं, कैसे चैलेंज करेगी या शायद उनसे हमआहंग हो जाएगी? क्या AI शफाफियत को बढ़ाएगा या उसे और भी पेचीदा बना देगा?
ये वाकई एक अहम सवाल है जिस पर गौर करने की जरूरत है। आने वाला वक्त ही बताएगा। नमस्कार। आज हम भारतीय श्रम कानूनों से जुड़े कुछ हालिया और कह सकते हैं बेहद जरूरी अदालती फैसलों पर बात करेंगे।
जी,
हमारे पास है हाई कोर्ट्स और सुप्रीम कोर्ट के कई अहम निर्णयों के नोट्स। ये खासतौर पर EPF, फिर वेतन की परिभाषा, रोजगार संबंध,
हाँ, और कार्यस्थल का बर्ताव, ये सब कवर करते हैं।
बिल्कुल। तो हमारा मकसद ये है कि इन जटिल कानूनी मामलों से जो सबसे जरूरी जानकारी है
उसे निकाला जाए।
हाँ, उसे निकालकर आसान भाषा में समझें। तो चलिए शुरू करते हैं। शायद EPF से जुड़े एक फैसले से शुरू करें, पंजाब और हरियाणा हाईकोर्ट वाला।
हाँ, वो अहम है।
कोर्ट ने कहा है कि अगर EPF एक्ट की धारा 7A के तहत कोई आदेश आया है और उस पर मान लीजिए ऊपरी अदालत ने रोक लगा दी, स्टे दे दिया,
जी,
तो फिर निचली अदालत उस नियोक्ता के खिलाफ कार्रवाई शुरू नहीं कर सकती। कम से कम तब तक जब तक वो रोक हट ना जाए। ये तो नियोक्ताओं के लिए एक बड़ी राहत लगती है ना।
बिल्कुल बिल्कुल, ये असल में न्यायिक प्रक्रिया के महत्व को दिखाता है। मतलब अगर किसी कंपनी पर ईपीएफ बकाया निकाला गया है और कंपनी उसे चुनौती देती है,
हाँ।
और हाई कोर्ट कह देता है कि भाई अभी रुको, इस पर रोक है, तो ईपीएफ विभाग तुरंत वसूली जैसी कार्रवाई नहीं कर सकता। एक तरह से कंपनियों को अपनी बात रखने का पूरा मौका मिलता है।
अच्छा।
और इसी तरह का एक और पॉइंट है मेघालय हाई कोर्ट का फैसला। वो कहता है कि अगर ईपीएफ अथॉरिटी अपना अधिकार क्षेत्र मतलब जुरिस्डिक्शन सही से इस्तेमाल नहीं करती,
हाँ।
तो कंपनी सीधे हाई कोर्ट में रिट याचिका दायर कर सकती है। तो ये एक और कानूनी रास्ता खुल जाता है।
यानी प्रक्रियात्मक निष्पक्षता पर काफी जोर दिया जा रहा है।
जी बिल्कुल।
अच्छा, अब जरा वेतन और ईपीएफ गणना पर आते हैं। मद्रास हाईकोर्ट और सुप्रीम कोर्ट का भी जिक्र है ब्रिजन रूफ को केस में।
हाँ, वो लैंडमार्क केस है।
उन्होंने ये साफ किया है कि ऐसे भत्ते जो सभी कर्मचारियों को एक जैसे नहीं मिलते,
सबको नहीं मिलते, हाँ,
उन्हें ईपीएफ काटने के लिए मूल वेतन यानी बेसिक वेज नहीं माना जाएगा। ये तो कंपनियों के लिए जानना बहुत जरूरी है।
हाँ बिल्कुल, ये आधारित है सार्वभौमिकता परीक्षण या यूनिवर्सैलिटी टेस्ट पर। आसान शब्दों में कहें तो पोर्ट ये देखता है कि क्या वो भत्ता उस पद के मतलब उस श्रेणी के सभी कर्मचारियों को मिल रहा है,
अच्छा,
या सिर्फ कुछ चुनिंदा लोगों को। अगर वो भत्ता सबके लिए नहीं है तो वो मूल वेतन का हिस्सा नहीं है और फिर उस पर ईपीएफ नहीं कटेगा।
तो इसका सीधा असर पड़ेगा कंपनियों की ईपीएफ देनदारी पर।
हाँ, और उनकी कंप्लायंस रणनीति पर भी। उन्हें अपनी सैलरी स्ट्रक्चर को शायद और ध्यान से देखना होगा।
लेकिन क्या इससे कंपनियों के लिए वो क्या कहते हैं डॉक्यूमेंटेशन का काम बढ़ नहीं जाता? उन्हें ये साबित करना होगा कि कोई भत्ता सार्वभौमिक क्यों नहीं है।
हाँ, ये एक पहलू जरूर है। पारदर्शिता और सही रिकॉर्ड रखना ये पहले से ज्यादा महत्वपूर्ण हो गया है। कंपनियों को अपनी वेतन संरचना को लेकर ज्यादा स्पष्टता रखनी होगी, ये सही है।
ठीक है, अब थोड़ा रोजगार संबंधों की तरफ बढ़ते हैं। राजस्थान हाईकोर्ट का एक फैसला कर्मचारियों के लिहाज से मुझे काफी अहम लगा।
कौन सा?
वो 240 दिनों की नौकरी वाला। कोर्ट ने कहा कि लगातार 240 दिनों की नौकरी की गिनती करते वक्त रविवार यानी हफ्ते की छुट्टी,
अच्छा, वीकली ऑफ,
हाँ, और दूसरी सवेतन छुट्टियां पेड लीव्स वो भी गिनी जानी चाहिए।
ओ, ये तो बहुत महत्वपूर्ण है। इसके मायने काफी गहरे हैं, खासकर जब किसी कर्मचारी को नौकरी से निकाला जाता है छटनी मुआवजे के लिए।
हाँ बिल्कुल,
क्योंकि अक्सर ये साबित करना मुश्किल होता है कि कर्मचारी ने लगातार 240 दिन काम किया है या नहीं। तो इस फैसले से कर्मचारियों के लिए अपनी सेवा की निरंतरता कंटिन्यूटी ऑफ सर्विस साबित करना आसान हो जाता है।
सही बात है, उनके अधिकार मजबूत होते हैं इससे।
हाँ, ये दिखाता है कि कानून की नजर में सेवा का मतलब सिर्फ वो दिन नहीं जब आपने काम किया, बल्कि रोजगार की निरंतरता है।
अच्छा, एक और मामला है जो थोड़ा अलग है, कार्यस्थल के माहौल से जुड़ा। बॉम्बे हाई कोर्ट का एक फैसला।
हाँ, वो बालों वाली टिप्पणी वाला मामला।
हाँ वही, जहाँ एक महिला सहकर्मी के बालों पर की गई टिप्पणी को यौन उत्पीड़न नहीं माना गया। कोर्ट ने इसमें क्या देखा?
कोर्ट ने पाया कि उनके आपसी संबंध सौहार्दपूर्ण थे, मतलब अच्छे थे, और टिप्पणी में कोई दुर्भावना, कोई गलत इरादा नहीं था।
लेकिन यहाँ ये समझना बहुत जरूरी है।
हाँ, ये बहुत जरूरी है
कि ये मामला बहुत खास तथ्यों और संदर्भ पर आधारित था। इस फैसले को लेकर बहुत सावधानी बरतनी चाहिए।
सही कहा। मतलब ये किसी भी तरह से कार्यस्थल पर यौन उत्पीड़न के खिलाफ जो कानून है उन्हें कमजोर नहीं करता।
कतई नहीं। ये सिर्फ ये दिखाता है कि किसी बर्ताव को कानूनी तौर पर कैसे देखा जाएगा, ये उस मामले के पूरे संदर्भ पर, आपसी रिश्तों पर, इरादे पर बहुत ज्यादा निर्भर करता है।
हर टिप्पणी या मजाक एक जैसा नहीं होता।
हाँ,
लेकिन इसका ये मतलब भी नहीं है कि कार्यस्थल पर किसी भी तरह की अनुचित टिप्पणी ठीक है। वो सीमा रेखा तो है ही।
बिल्कुल। तो अगर हम इन सब फैसलों के एक साथ देखें तो क्या तस्वीर उभरती है? मुझे लगता है ये साफ है कि श्रम कानून कितना गतिशील है, लगातार बदल रहा है।
हाँ बिल्कुल।
ईपीएफ गणना के तकनीकी नियमों से लेकर रोजमर्रा के दफ्तरी बर्ताव तक अधिकार और जिम्मेदारियां लगातार स्पष्ट हो रही हैं।
हाँ, और अदालतें लगातार एक संतुलन बनाने की कोशिश कर रही हैं किस किस के बीच, कानूनी प्रावधान, कर्मचारियों के अधिकार, प्रक्रियात्मक निष्पक्षता,
जैसे सही नोटिस देना, अपील का मौका देना।
हाँ, और साथ ही व्यापार की जो वास्तविकताएं हैं उनके बीच पारदर्शिता पर भी जोर बढ़ रहा है। जैसे कलकत्ता हाईकोर्ट का एक फैसला है,
अच्छा,
कि ईपीएफओ को अगर हर्जाना लगाना है तो उसकी गणना का पूरा ब्यौरा देना होगा, क्यों लगाया, कैसे लगाया, सब बताना होगा।
ये तो बहुत अच्छा है, पारदर्शिता जरूरी है।
जी, और ये सब हमें एक अहम सवाल पर सोचने को मजबूर करता है।
क्या?
कि जिस तरह से कानून की व्याख्याएं बदल रही हैं, प्रक्रियात्मक निष्पक्षता पर जोर दिया जा रहा है, उसे देखते हुए कंपनियां भविष्य में इस जटिल कानूनी माहौल में सही ढंग से काम करने के लिए अपनी अंदरूनी प्रक्रियाओं को, अपने दस्तावेजों को पहले से कैसे बेहतर बना सकती हैं, प्रोएक्टिवली कैसे तैयारी कर सकती हैं।
वाकई ये एक सोचने वाला सवाल है। खैर, हमारा इरादा यही था कि इन महत्वपूर्ण कानूनी अपडेट्स का एक स्पष्ट और संक्षिप्त ऑडियो अवलोकन पेश किया जाए।
जी,
उम्मीद है श्रोताओं को इससे मदद मिली होगी।
ਸਵਾਗਤ ਹੈ ਜੀ ਸਾਰਿਆਂ ਦਾ। ਅੱਜ ਅਸੀਂ ਗੱਲ ਕਰਾਂਗੇ ਭਾਰਤੀ ਕਿਰਤ ਕਾਨੂੰਨ ਬਾਰੇ, ਖਾਸ ਕਰਕੇ ਕੁਝ ਜਿਹੜੇ ਹਾਲ ਹੀ ਵਿੱਚ ਅਦਾਲਤੀ ਫੈਸਲੇ ਆਏ ਨੇ।
ਹਾਂਜੀ,
ਸਾਡੇ ਕੋਲ ਕਾਫੀ ਨੋਟਸ ਨੇ ਹਾਈ ਕੋਰਟਾਂ ਦੇ ਵੀ ਤੇ ਸੁਪਰੀਮ ਕੋਰਟ ਦੇ ਵੀ, ਤੇ ਅੱਜ ਕੋਸ਼ਿਸ਼ ਕਰਾਂਗੇ ਇਹਨਾਂ ਨੂੰ ਥੋੜਾ ਜਿਹਾ ਡੂੰਘਾਈ ਨਾਲ ਸਮਝਣ ਦੀ।
ਬਿਲਕੁਲ। ਦੇਖੋ, ਇਹ ਜਿਹੜੇ ਸਰੋਤ ਨੇ, ਇਹਨਾਂ ਤੋਂ ਪਤਾ ਲੱਗਦਾ ਹੈ ਕਿ ਅਦਾਲਤਾਂ ਨਾ ਕਾਫੀ ਬਾਰੀਕੀ ਨਾਲ ਦੇਖ ਰਹੀਆਂ ਨੇ ਚੀਜ਼ਾਂ ਨੂੰ, ਜਿਵੇਂ EPF ਹੋ ਗਿਆ, ਯਾਨੀ ਕਰਮਚਾਰੀ ਭਵਿੱਖ ਨਿਧੀ।
ਹਾਂ, EPF।
ਫਿਰ ਤਨਖਾਹ ਦੀ ਪਰਿਭਾਸ਼ਾ, ਨੌਕਰੀ ਤੋਂ ਕੱਢਣਾ, ਇਹ ਸਾਰੇ ਮੁੱਦੇ। ਤੇ ਆਪਣਾ ਮਕਸਦ ਇਹੀ ਹੈ ਕਿ ਇਹਨਾਂ ਗੁੰਝਲਦਾਰ ਫੈਸਲਿਆਂ ਚੋਂ ਮੁੱਖ ਗੱਲਾਂ ਕੱਢ ਕੇ ਸੌਖੀ ਭਾਸ਼ਾ 'ਚ ਸਮਝਾਈਏ।
ਚਲੋ ਫਿਰ ਸ਼ੁਰੂ ਕਰਦੇ ਹਾਂ EPF ਤੋਂ ਹੀ। ਇੱਕ ਬੜੀ ਦਿਲਚਸਪ ਗੱਲ ਸਾਹਮਣੇ ਆਈ ਹੈ। ਜੇਕਰ ਧਾਰਾ 7A ਜਿਹੜੀ EPF ਬਕਾਇਆ ਨਿਰਧਾਰਿਤ ਕਰਦੀ ਏ, ਉਸਦੇ ਹੁਕਮ ਤੇ ਅਦਾਲਤ ਰੋਕ ਲਗਾ ਦੇਵੇ, ਮਤਲਬ ਸਟੇ ਦੇ ਦੇਵੇ,
ਹਾਂਜੀ,
ਤਾਂ ਫਿਰ ਟ੍ਰਾਇਲ ਕੋਰਟ ਮਾਲਕ ਨੂੰ ਸਮਨ ਨਹੀਂ ਭੇਜ ਸਕਦੀ ਉਸੇ ਮਾਮਲੇ 'ਚ। ਇਹ ਪੰਜਾਬ ਤੇ ਹਰਿਆਣਾ ਹਾਈ ਕੋਰਟ ਦਾ ਫੈਸਲਾ ਹੈ। ਇਹਦਾ ਮਤਲਬ ਕੀ ਹੋਇਆ ਮਾਲਕਾਂ ਲਈ?
ਦੇਖੋ ਜੀ, ਇਹ ਮਾਲਕਾਂ ਲਈ ਇੱਕ ਤਰ੍ਹਾਂ ਦੀ ਸੁਰੱਖਿਆ ਹੈ। ਮਤਲਬ ਜੇ EPF ਵਾਲਿਆਂ ਦੇ ਮੁਲਾਂਕਣ ਨੂੰ ਚੁਣੌਤੀ ਦਿੱਤੀ ਹੋਈ ਹੈ ਹਾਈ ਕੋਰਟ 'ਚ ਤੇ ਰੋਕ ਲੱਗੀ ਹੋਈ ਹੈ,
ਅੱਛਾ,
ਤਾਂ ਫਿਰ ਹੇਠਲੀ ਅਦਾਲਤ ਉਸੇ ਬਕਾਏ ਲਈ ਵੱਖਰੀ ਕਾਰਵਾਈ ਨਹੀਂ ਸ਼ੁਰੂ ਕਰ ਸਕਦੀ। ਇਸ ਨਾਲ ਨਾ ਥੋੜੀ ਇਕਸਾਰਤਾ ਆਉਂਦੀ ਹੈ ਕਾਨੂੰਨੀ ਕਾਰਵਾਈ 'ਚ।
ਠੀਕ ਹੈ।
ਤੇ ਇਸੇ ਤਰ੍ਹਾਂ ਕਲਕੱਤਾ ਹਾਈ ਕੋਰਟ ਨੇ ਵੀ ਇੱਕ ਅਹਿਮ ਗੱਲ ਕਹੀ ਹੈ EPFO ਨੂੰ, ਕਿ ਜੇ ਤੁਸੀਂ ਦੇਰੀ ਲਈ ਹਰਜਾਨਾ ਯਾਨੀ ਡੈਮੇजेस ਲਗਾਉਂਦੇ ਹੋ,
ਹਾਂ, ਉਹ ਲਗਾਉਂਦੇ ਨੇ,
ਤਾਂ ਤੁਹਾਨੂੰ ਪੂਰਾ ਹਿਸਾਬ ਕਿਤਾਬ ਤਰੀਕਾ ਦੱਸਣਾ ਪਊਗਾ। ਐਵੇਂ ਅੰਦਾਜ਼ੇ ਨਾਲ ਨਹੀਂ ਚੱਲਣਾ।
ਅੱਛਾ, ਯਾਨੀ ਪੂਰੀ ਪਾਰਦਰਸ਼ਿਤਾ ਚਾਹੀਦੀ ਹੈ। ਇਹ ਤਾਂ ਸਹੀ ਗੱਲ ਹੈ। ਮਾਲਿਕ ਨੂੰ ਪਤਾ ਤਾਂ ਹੋਵੇ ਕਿ ਪੈਸੇ ਕਿਸ ਗੱਲ ਦੇ ਮੰਗ ਰਹੇ ਨੇ।
ਬਿਲਕੁਲ।
ਅੱਗੇ ਚੱਲਦੇ ਹਾਂ। ਇੱਕ ਹੋਰ ਮੁੱਦਾ ਹੈ EPF ਵਿੱਚ ਮੁੱਢਲੀ ਤਨਖਾਹ ਯਾਨੀ ਬੇਸਿਕ ਵੇਜ ਦਾ। ਇਹ ਹਮੇਸ਼ਾ ਹੀ ਥੋੜਾ ਉਲਝਿਆ ਰਹਿੰਦਾ ਹੈ। ਸਰੋਤ ਕਹਿੰਦੇ ਨੇ ਕਿ ਜੇ ਕੋਈ ਭੱਤਾ ਸਾਰੇ ਕਰਮਚਾਰੀਆਂ ਨੂੰ ਨਹੀਂ ਮਿਲਦਾ, ਤਾਂ ਉਹ ਬੇਸਿਕ ਵੇਜ ਦਾ ਹਿੱਸਾ ਨਹੀਂ ਹੈ EPF ਲਈ।
ਹਾਂਜੀ, ਇਹ ਨਾ ਸੁਪਰੀਮ ਕੋਰਟ ਦਾ ਪੁਰਾਣਾ ਫੈਸਲਾ ਹੈ, ਬ੍ਰਿਜ ਐਂਡ ਰੂਫ ਕੰਪਨੀ ਵਾਲਾ। ਉਸੇ ਸਿਧਾਂਤ ਤੇ ਇਹ ਮਦਰਾਸ ਹਾਈ ਕੋਰਟ ਨੇ ਹੁਣ ਇਹਨੂੰ ਦੁਹਰਾਇਆ ਹੈ।
ਤਾਂ ਇਹਦਾ ਸਿੱਧਾ ਅਸਰ ਕੀ ਪੈਂਦਾ ਹੈ?
ਸਿੱਧਾ ਅਸਰ ਇਹ ਹੈ ਕਿ ਜੇ ਕੋਈ ਅਲਾਉਂਸ, ਮਤਲਬ ਕੋਈ ਭੱਤਾ ਸਿਰਫ ਖਾਸ ਹਾਲਾਤਾਂ 'ਚ ਜਾਂ ਕੁਝ ਲੋਕਾਂ ਨੂੰ ਮਿਲਦਾ ਹੈ, ਤਾਂ ਉਸ ਰਕਮ ਤੇ EPF ਨਹੀਂ ਕੱਟਿਆ ਜਾਵੇਗਾ। ਇਸ ਨਾਲ ਕੰਪਨੀ ਦੀ ਲਾਗਤ ਘਟ ਸਕਦੀ ਹੈ ਤੇ ਹੋ ਸਕਦਾ ਹੈ ਕਰਮਚਾਰੀ ਦੀ ਇਨ ਹੈਂਡ ਸੈਲਰੀ ਵੱਧ ਜਾਵੇ। ਇਹ ਸਪਸ਼ਟ ਕਰਦਾ ਹੈ ਕਿ ਕਿਹੜੀ ਚੀਜ਼ ਤੇ EPF ਲੱਗਣਾ ਹੈ, ਕਿਹੜੀ ਤੇ ਨਹੀਂ।
ਠੀਕ ਹੈ, ਠੀਕ ਹੈ। ਇੱਕ ਹੋਰ ਬੜੀ ਪ੍ਰੈਕਟੀਕਲ ਜੀ ਗੱਲ ਕਲਕੱਤਾ ਹਾਈ ਕੋਰਟ ਤੋਂ ਆਈ ਹੈ।
ਹਾਂਜੀ,
ਜਿਹੜੀਆਂ ਕੰਪਨੀਆਂ ਦੀ ਮਾਲੀ ਹਾਲਤ ਠੀਕ ਨਹੀਂ,
ਹਾਂਜੀ,
ਉਹਨਾਂ ਨੂੰ EPF ਦੇ ਬਕਾਏ ਤੇ ਹਰਜਾਨਾ ਕਿਸ਼ਤਾਂ 'ਚ ਦੇਣ ਦੀ ਇਜਾਜ਼ਤ ਦਿੱਤੀ ਹੈ।
ਬਿਲਕੁਲ। ਇਹ ਦੱਸਦਾ ਹੈ ਕਿ ਅਦਾਲਤਾਂ ਸਿਰਫ ਕਾਨੂੰਨ ਹੀ ਨਹੀਂ ਦੇਖ ਰਹੀਆਂ, ਬਲਕਿ ਕਾਰੋਬਾਰਾਂ ਦੀ ਅਸਲ ਆਰਥਿਕ ਸਥਿਤੀ ਨੂੰ ਵੀ ਸਮਝ ਰਹੀਆਂ ਨੇ। ਇੱਕ ਤਰ੍ਹਾਂ ਦਾ ਸੰਤੁਲਨ ਬਣਾਉਣ ਦੀ ਕੋਸ਼ਿਸ਼ ਹੈ।
ਸਹੀ ਗੱਲ ਹੈ। ਕਾਨੂੰਨ ਦੀ ਪਾਲਣਾ ਵੀ ਹੋਵੇ ਤੇ ਕੰਮ ਵੀ ਚੱਲਦਾ ਰਹੇ। ਅੱਛਾ, EPF ਤੋਂ ਹਟ ਕੇ ਹੁਣ ਰੁਜ਼ਗਾਰ ਦੇ ਰਿਸ਼ਤੇ ਦੀ ਗੱਲ ਕਰੀਏ।
ਹਾਂਜੀ,
ਸੁਪਰੀਮ ਕੋਰਟ ਦਾ ਇੱਕ ਫੈਸਲਾ ਆਇਆ ਹੈ ਜਿਹੜਾ ਸ਼ਾਇਦ ਥੋੜਾ ਹੈਰਾਨ ਕਰੇ।
ਕਿਹੜਾ ਜੀ?
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਜੇ ਕੋਈ ਠੇਕੇਦਾਰ ਦਾ ਬੰਦਾ, ਮਤਲਬ ਕੰਟਰੈਕਟ ਲੇਬਰ,
ਹਾਂਜੀ,
ਲੰਮਾ ਸਮਾਂ ਇੱਕੋ ਹੀ ਮੁੱਖ ਮਾਲਕ ਕੋਲ ਕੰਮ ਕਰੀ ਜਾਵੇ,
ਹਾਂ, ਅਕਸਰ ਹੁੰਦਾ ਹੈ,
ਤਾਂ ਵੀ ਜ਼ਰੂਰੀ ਨਹੀਂ ਕਿ ਉਹ ਸਿੱਧਾ ਮੁੱਖ ਮਾਲਕ ਦਾ ਕਰਮਚਾਰੀ ਬਣ ਜਾਵੇ।
ਹਾਂ, ਇਹ ਗੱਲ ਪ੍ਰਭਾਵੀ ਕੰਟਰੋਲ ਤੇ ਨਿਰਭਰ ਕਰਦੀ ਹੈ। ਅਦਾਲਤ ਇਹ ਦੇਖਦੀ ਹੈ ਕਿ ਅਸਲ ਕੰਟਰੋਲ ਕਿਸ ਦਾ ਹੈ। ਤਨਖਾਹ, ਛੁੱਟੀ, ਡਿਸਪਲਿਨ, ਇਹ ਸਭ ਕੌਣ ਤੈਅ ਕਰਦਾ ਹੈ, ਠੇਕੇਦਾਰ ਜਾਂ ਮੁੱਖ ਮਾਲਕ?
ਅੱਛਾ, ਮਤਲਬ ਜੇ ਠੇਕੇਦਾਰ ਦਾ ਕੰਟਰੋਲ ਜ਼ਿਆਦਾ ਹੈ?
ਹਾਂਜੀ, ਜੇ ਠੇਕੇਦਾਰ ਦਾ ਕੰਟਰੋਲ ਅਸਲ 'ਚ ਹੈ ਤਾਂ ਕਰਮਚਾਰੀ ਉਸੇ ਦਾ ਮੰਨਿਆ ਜਾਵੇਗਾ, ਭਾਵੇਂ ਉਹ ਕੰਮ ਕਿਸੇ ਹੋਰ ਦੀ ਫੈਕਟਰੀ ਜਾਂ ਦਫ਼ਤਰ 'ਚ ਕਰ ਰਿਹਾ ਹੋਵੇ। ਇਹ ਕੰਟਰੈਕਟ ਲੇਬਰ ਲਈ ਬਹੁਤ ਅਹਿਮ ਸਪਸ਼ਟੀਕਰਨ ਹੈ।
ਇਹ ਤਾਂ ਕਾਫੀ ਵੱਡਾ ਪੁਆਇੰਟ ਹੈ। ਅੱਛਾ, ਇਸੇ ਨਾਲ ਜੁੜਿਆ ਇੱਕ ਹੋਰ ਫੈਸਲਾ ਹੈ ਰਾਜਸਥਾਨ ਹਾਈ ਕੋਰਟ ਦਾ ਕਰਮਚਾਰੀਆਂ ਦੇ ਹੱਕਾਂ ਬਾਰੇ। ਲਗਾਤਾਰ ਸੇਵਾ ਦੇ 240 ਦਿਨ ਕਿਵੇਂ ਗਿਣਨੇ ਨੇ?
ਹਾਂ, ਇਹ ਵੀ ਬਹੁਤ ਜ਼ਰੂਰੀ ਹੈ। ਉਹਨਾਂ ਨੇ ਕਿਹਾ ਹੈ ਕਿ 240 ਦਿਨਾਂ ਦੀ ਗਿਣਤੀ ਕਰਦੇ ਸਮੇਂ ਐਤਵਾਰ ਤੇ ਜਿਹੜੀਆਂ ਤਨਖਾਹ ਵਾਲੀਆਂ ਛੁੱਟੀਆਂ ਹੁੰਦੀਆਂ ਨੇ, ਉਹਨਾਂ ਨੂੰ ਵੀ ਕੰਮ ਦੇ ਦਿਨਾਂ 'ਚ ਗਿਣਿਆ ਜਾਣਾ ਚਾਹੀਦਾ ਹੈ।
ਅੱਛਾ,
ਯਾਨੀ ਛੁੱਟੀਆਂ ਕੱਢ ਕੇ ਨਹੀਂ ਗਿਣਨਾ, ਨਹੀਂ, ਛੁੱਟੀਆਂ ਮਿਲਾ ਕੇ। ਇਹ ਖਾਸ ਕਰਕੇ ਛਾਂਟੀ ਵੇਲੇ ਜਾਂ ਗ੍ਰੈਚੁਇਟੀ ਵਰਗੇ ਲਾਭਾਂ ਲਈ ਯੋਗਤਾ ਦੇਖਣ ਵੇਲੇ ਬਹੁਤ ਫਰਕ ਪਾਉਂਦਾ ਹੈ। ਕਰਮਚਾਰੀਆਂ ਲਈ ਇੱਕ ਤਰ੍ਹਾਂ ਦੀ ਸੁਰੱਖਿਆ ਵਧਾਉਂਦਾ ਹੈ।
ਠੀਕ ਹੈ। ਹੁਣ ਥੋੜੀ ਗੱਲ ਕਰੀਏ ਪ੍ਰਕਿਰਿਆ ਦੀ, ਯਾਨੀ ਪ੍ਰੋਸੀਜਰਲ ਫੇਅਰਨੈਸ ਦੀ। ਮਦਰਾਸ ਹਾਈ ਕੋਰਟ ਨੇ ਕਿਹਾ ਕਿ ਜੇ ਕਿਸੇ ਮੁਲਾਜ਼ਮ ਖਿਲਾਫ ਕੋਈ ਅਨੁਸ਼ਾਸਨੀ ਯਾਨੀ ਡਿਸਪਲਿਨਰੀ ਇਨਕੁਆਇਰੀ ਇੱਕੋ ਦਿਨ ਸ਼ੁਰੂ ਕਰਕੇ ਉਸੇ ਦਿਨ ਖਤਮ ਕਰ ਦਿੱਤੀ ਜਾਵੇ।
ਹੈ ਇੱਕੋ ਦਿਨ 'ਚ?
ਹਾਂ, ਤਾਂ ਉਹ ਗੈਰ ਕਾਨੂੰਨੀ ਹੈ, ਕਾਲੀ ਨਹੀਂ ਕਰਨੀ।
ਬਿਲਕੁਲ ਸਹੀ ਗੱਲ ਹੈ। ਇਹ ਤਾਂ ਕੁਦਰਤੀ ਨਿਆਂ ਦੇ ਸਿਧਾਂਤ ਦੇ ਖਿਲਾਫ ਹੈ। ਦੇਖੋ, ਕਰਮਚਾਰੀ ਨੂੰ ਆਪਣਾ ਪੱਖ ਰੱਖਣ ਦਾ, ਸਬੂਤ ਦੇਣ ਦਾ, ਗਵਾਹਾਂ ਤੋਂ ਸਵਾਲ ਪੁੱਛਣ ਦਾ ਪੂਰਾ ਮੌਕਾ ਮਿਲਣਾ ਚਾਹੀਦਾ ਹੈ।
ਹਾਂਜੀ,
ਇੱਕ ਦਿਨ 'ਚ ਸਭ ਕਿਵੇਂ ਹੋ ਸਕਦਾ ਹੈ? ਐਵੇਂ ਖਾਣਾ ਪੂਰਤੀ ਥੋੜੀ ਕਰਨੀ ਹੈ। ਇਹ ਬਹੁਤ ਜ਼ਰੂਰੀ ਪ੍ਰਕਿਰਿਆਤਮਕ ਸੁਰੱਖਿਆ ਹੈ।
ਤੇ ਇਸੇ ਤਰ੍ਹਾਂ ਦੀ ਗੱਲ ESIC ਯਾਨੀ ਕਰਮਚਾਰੀ ਰਾਜ ਬੀਮਾ ਨਿਗਮ ਦੇ ਮਾਮਲੇ 'ਚ ਬੰਬਈ ਹਾਈ ਕੋਰਟ ਨੇ ਕਹੀ।
ਅੱਛਾ, ਉਹ ਕੀ ਸੀ?
ਉਹਨਾਂ ਨੇ ਕਿਹਾ ਕਿ ESIC ਉਹਨਾਂ ਖਾਤਿਆਂ ਦੇ ਹੈਡਸ ਹੇਠ ਪੈਸੇ ਨਹੀਂ ਮੰਗ ਸਕਦਾ ਜਿਨ੍ਹਾਂ ਦਾ ਜ਼ਿਕਰ ਸ਼ੁਰੂਆਤੀ ਕਾਰਨ ਦੱਸੋ ਨੋਟਿਸ ਯਾਨੀ ਸ਼ੋਕਾਜ਼ ਨੋਟਿਸ ਵਿੱਚ ਹੈ ਹੀ ਨਹੀਂ ਸੀ।
ਓ, ਇਹ ਵੀ ਬਹੁਤ ਵਧੀਆ ਗੱਲ ਹੈ। ਮਤਲਬ ਜਿਹੜੇ ਇਲਜ਼ਾਮ ਸ਼ੁਰੂ 'ਚ ਲਾਏ ਸੀ, ਗੱਲ ਉਸੇ ਦੀ ਹੋਊਗੀ। ਐਵੇਂ ਬਾਅਦ 'ਚ ਨਵੀਆਂ ਚੀਜ਼ਾਂ ਨਹੀਂ ਜੋੜ ਸਕਦੇ।
ਹਾਂ, ਮਾਲਿਕ ਨੂੰ ਪਤਾ ਤਾਂ ਹੋਵੇ ਕਿ ਜਵਾਬ ਕਿਸ ਚੀਜ਼ ਦਾ ਦੇਣਾ ਹੈ।
ਬਿਲਕੁਲ, ਇਹ ਵੀ ਪਾਰਦਰਸ਼ਤਾ ਤੇ ਨਿਰਪੱਖਤਾ ਵਾਲੀ ਗੱਲ ਹੋ ਗਈ।
ਤਾਂ ਜੇ ਆਪਾਂ ਸਾਰੀਆਂ ਗੱਲਾਂ ਨੂੰ ਜੋੜੀਏ, ਓਵਰਆਲ ਦੇਖੀਏ, ਤਾਂ ਕੀ ਤਸਵੀਰ ਬਣਦੀ ਹੈ? ਮੈਨੂੰ ਤਾਂ ਲੱਗਦਾ ਅਦਾਲਤਾਂ ਕਾਫੀ ਬਾਰੀਕੀ ਜਾ ਰਹੀਆਂ ਨੇ।
ਹਾਂਜੀ, ਬਿਲਕੁਲ। ਤੇ ਕਈ ਚੀਜ਼ਾਂ ਸਾਹਮਣੇ ਆ ਰਹੀਆਂ ਨੇ, ਜਿਵੇਂ ਪ੍ਰਕਿਰਿਆ ਸਹੀ ਹੋਣੀ ਚਾਹੀਦੀ ਹੈ, ਪਾਰਦਰਸ਼ਤਾ ਹੋਣੀ ਚਾਹੀਦੀ ਹੈ, ਮਾਲਿਕ ਤੇ ਕਰਮਚਾਰੀ ਦੇ ਹੱਕਾਂ 'ਚ ਇੱਕ ਸੰਤੁਲਨ ਬਣਾਉਣ ਦੀ ਕੋਸ਼ਿਸ਼ ਹੋ ਰਹੀ ਹੈ। ਤੇ ਕਈ ਵਾਰ ਕਾਨੂੰਨ ਨੂੰ ਅਸਲ ਜ਼ਿੰਦਗੀ ਦੀਆਂ ਆਰਥਿਕ ਮਜਬੂਰੀਆਂ ਨਾਲ ਮਿਲਾ ਕੇ ਦੇਖਿਆ ਜਾ ਰਿਹਾ ਹੈ। ਇਹ ਫੈਸਲੇ ਸਿਰਫ ਕਾਨੂੰਨੀ ਸਵਾਲਾਂ ਦੇ ਜਵਾਬ ਨਹੀਂ, ਇਹ ਕੰਮ ਵਾਲੀ ਥਾਂ ਦਾ ਮਾਹੌਲ ਵੀ ਬਦਲਦੇ ਨੇ।
ਸਹੀ ਗੱਲ ਹੈ। ਤਾਂ ਫਿਰ ਸੁਣਨ ਵਾਲਿਆਂ ਲਈ ਇੱਕ ਸਵਾਲ ਛੱਡ ਜਾਈਏ।
ਹਾਂਜੀ, ਜ਼ਰੂਰ।
ਜਿਸ ਤਰ੍ਹਾਂ ਅਦਾਲਤਾਂ ਇਹਨਾਂ ਮੁੱਦਿਆਂ ਨੂੰ ਦੇਖ ਰਹੀਆਂ ਨੇ, ਕੰਟਰੋਲ, ਪਾਰਦਰਸ਼ਿਤਾ, ਪ੍ਰਕਿਰਿਆ, ਇਹ ਸਭ ਦਾ ਭਵਿੱਖ ਵਿੱਚ ਭਾਰਤ ਵਿੱਚ ਕੰਮ ਵਾਲੀ ਥਾਂ ਤੇ ਮਤਲਬ ਮਾਲਿਕ ਕਰਮਚਾਰੀ ਦੇ ਰਿਸ਼ਤੇ ਤੇ ਉਹਨਾਂ ਦੀ ਆਪਸੀ ਗੱਲਬਾਤ ਤੇ ਕੀ ਅਸਰ ਪਵੇਗਾ? ਇਸ ਬਾਰੇ ਸੋਚਣਾ ਦਿਲਚਸਪ ਹੋਵੇਗਾ ਨਾ?
ਬਿਲਕੁਲ, ਇਸ ਬਾਰੇ ਵਿਚਾਰ ਕਰਨਾ ਬਣਦਾ ਹੈ।
Welcome to the deep dive. Today, we're jumping into the pretty complex world of Indian labor law.
Yeah, it's a landscape where court judgments are constantly clarifying things, aren't they?
Exactly. Think of these rulings less like dry legal text and more like essential signposts. They give real guidance on what employers need to do and what rights employees have.
And our goal today really is to cut through the jargon, right?
Absolutely. We're diving into a whole collection of recent significant judgments from the high courts and the Supreme Court. We've got summaries, excerpts, the real deal.
And we want to distill the core insights, the sometimes surprising facts, making it all understandable.
Whether you're making business decisions, figuring out your own rights, or just curious about how workplaces in India are shaped by law, this deep dive is for you. We're extracting the key stuff.
And you know, what really stands out when you look at these judgments together is the court's commitment. They're focused on fair procedures, what we call natural justice.
Acting as a check on bodies like the EPFO and ESIC, making sure they follow the rules.
Precisely. Keeping them operating within the legal framework.
Okay, so let's unpack that, starting with the EPF, the Employees Provident Fund. This seems to be a big area for judicial oversight.
It really is. Take a ruling from the Punjab and Haryana High Court. It tackles Section 7A orders.
Right, Section 7A, that's about figuring out how much EPF an employer owes, isn't it?
Exactly. And the court said quite clearly that if a judicial stay is granted on that Section 7A order,
Meaning a higher court has paused it.
yes. If that order is paused, then trial courts can't just go ahead with prosecuting the employer based on that order, not until the stay is lifted.
Okay, so what's the real-world impact there for an employer?
Well, it's significant protection. Say you're challenging an EPF assessment and you get that stay. This ruling means a lower court can't simultaneously start a criminal case against you based on the very assessment you're challenging.
Makes sense. The foundation of the prosecution is still up in the air.
Exactly. It ensures the legal process happens in the right order. You settle the assessment dispute first. It also prevents potentially wasted court time on prosecutions that might become irrelevant.
Right, you shouldn't face penalties while the penalty basis is being fought over. Now, speaking of challenging EPF orders, what if the EPF authorities themselves mess up the process?
Ah, yes. The Meghalaya High Court addressed that. They ruled that writ petitions are maintainable if the EPF authorities make serious procedural errors or, don't exercise their jurisdiction properly under Section 14B, which deals with damages.
Okay, writ petition and maintainable. Can you break that down? Usually there's an appeal process within the EPF system, right?
Normally, you'd appeal internally first, but a writ petition is a direct request to the High Court to step in because a lower body acted unlawfully or unfairly.
So it's a faster route.
It can be. The Meghalaya Court is saying if the EPF authorities really got it wrong, maybe ignored key evidence, or acted beyond their legal powers, the employer doesn't have to slog through all the internal appeals first. They can go straight to the High Court.
Like a safety valve when the system itself fails?
Precisely. It's crucial when the standard appeal path might not fix a fundamentally flawed decision. Saves time, saves resources.
Got it. And it seems courts also step in when the system physically breaks down. There was a Kerala High Court ruling about EPF recovery.
Yes, involving garnish proceedings where they seize funds.
Right. The court said it could step in and halt those proceedings under Article 226 if the appellate tribunals weren't functional.
This really hits at the core of access to justice. Imagine you have the right to appeal, but the place you need to appeal to just isn't operating.
You're stuck.
You're stuck. And the Kerala High Court said, well, allowing the EPF to seize your assets in that situation when you literally can't exercise your right to appeal is fundamentally unfair. It violates natural justice, undermines the rule of law.
Wow. So the High Court used its extraordinary powers to prevent that injustice.
Exactly. It ensured the breakdown in the system didn't lead to an unfair outcome for the employer.
That's a really clear example. Now, what about the calculations themselves? How are damages figured out? The Calcutta High Court seems to want more transparency from the EPFO.
They do. They ruled very definitively that the EPFO has to provide detailed explanations for damage calculations. That includes the complete methodology used.
Seems basic, right? Show your work.
You'd think so, but the court felt the need to spell it out. They explicitly said the burden is on the EPFO, not the employer, to prove the calculations are valid and accurate.
So the EPFO has to lay out the formula, the data, the legal basis.
Everything. So the employer can actually understand how they arrived at that figure and can challenge it properly if they think there's a mistake.
Makes perfect sense. You can't fight what you don't understand. And deadlines don't just apply to employers, right?
Yeah.
The Madras High Court pulled up the EPFO for being too slow.
Yeah, that was a significant one. They rejected an EPFO challenge to a tribunal order because the EPFO waited, 5 or 6 years?
5 or 6 years. Wow. Why did the court reject it so strongly?
It comes down to a legal principle called latches. Basically, you can't just sit on your rights forever, especially if your delay harms the other party. Waiting that long created huge uncertainty. The court said this is a reminder to all statutory bodies, EPFO included. You have to challenge decisions you disagree with in a reasonable time frame, even if there isn't a specific deadline written in the law.
So bringing finality to matters. You can't have things hanging over people's heads indefinitely.
Precisely. Justice delayed is justice denied, even for the authorities sometimes.
Okay, let's shift gears slightly. What about businesses that are genuinely struggling financially? Can they get some leeway on EPF damages?
Yes, the Calcutta High Court showed some pragmatism here. They ruled that financially distressed companies, sick companies as they're sometimes called, might be allowed to pay EPF damages in installments.
That seems sensible. Forcing a struggling company to pay a lump sum could just push it over the edge, right?
Exactly. That could lead to bankruptcy, job losses, a worse outcome overall. So the court said, okay, let's look at reasonable installment plans based on the company's actual financial situation.
So it's a balancing act. Get the dues paid eventually, but don't kill the company in the process.
That's the idea, balancing compliance with economic reality.
And on a related note, what if an employer gets a Section 7A assessment, disputes it, but then pays the assessed amount within the time frame given in the order? Are they still liable for interest and damages on that amount later?
Good question. The Madras High Court confirmed that if an employer deposits the contribution as determined under Section 7A within the time allowed by that order, they're shielded from interest under Section 7Q and damages under Section 14B for that specific assessed period.
So paying promptly after the assessment, even if you initially defaulted, protects you from those extra penalties for that assessed amount.
That's right. It encourages timely compliance once the liability is formally determined by the authorities.
Okay. Now, what about appealing EPF damage orders? Is there any flexibility if an employer misses the deadline to appeal?
There can be, yes. Another Madras High Court ruling suggests that appeals might be allowed even after the official limitation period, provided the employer has legitimate reasons for the delay.
Like what sort of reasons?
The ruling doesn't specify, but you'd imagine things like genuine administrative errors, perhaps delays in receiving the order, or other unavoidable circumstances. But there's a condition.
Okay.
The court said the employer usually has to deposit the interest amount, often monthly, while the appeal is ongoing.
So you get a chance to argue the damages appeal late, but you have to keep paying the interest in the meantime.
That seems to be the arrangement suggested. It balances giving a fair hearing with ensuring ongoing financial compliance during the appeal.
Interesting. Okay, let's dive into a really fundamental question for EPF. What actually counts as basic wage for calculating contributions?
Ah, yes. This is a classic issue. The Madras High Court, referencing the big Supreme Court case, Bridge and Roof Cone, reiterated a key principle.
Which is?
If an allowance isn't earned universally by all employees, it's generally excluded from basic wage for EPF purposes.
So the universality test, if not everyone gets it, it's probably not basic wage.
That's the core idea. Allowances that are conditional, maybe linked to individual performance, specific roles, location, things like that, usually fall outside the Section 2B definition of basic wages.
Can you give an example?
Sure. Think about a standard dearness allowance that everyone gets that's likely basic wage. But a special project bonus only given to a few team members, probably not basic wage for EPF.
Okay, that distinction is helpful. So universality is key. Now back to appeals. If an employer pays the interest due on delayed EPF payments, does that mean they automatically lose the right to appeal the damages that were also imposed?
No, not necessarily. The Karnataka High Court tackled this. They said the Central Government Industrial Tribunal, the CGIT, has to consider the appeal against the damages on its merits, even if the employer has already paid the interest.
So paying the interest penalty doesn't mean you agree the damage penalty was fair.
Exactly. The court was clear. Paying the statutory interest doesn't waive your right to argue against the punitive damages. The CGIT needs to look at the substance of the damage appeal itself.
That preserves the right to challenge penalties you think are unfair, even if you've covered the interest part. Good to know. Now, what about getting a temporary halt on EPF damage orders during an appeal? How does that interact with pre-deposit rules?
Right. Another important distinction made by the Madras High Court. They clarified that conditions imposed when granting a stay order are different from mandatory pre-deposit requirements.
What's the practical difference for a business?
It can mean a lower upfront financial burden. A pre-deposit usually means paying a fixed, often large percentage of the disputed amount just to file the appeal. A conditional stay might involve providing some security, but it's not necessarily the same rigid, potentially crippling upfront payment.
So getting a stay might be financially easier than meeting a formal pre-deposit rule, allowing more businesses to pursue appeals.
That's the potential benefit, yes. It makes the appeal process more accessible.
Seems like a lifeline. But even with an appeal ongoing, the EPFO needs to collect funds, right? Can they cash demand drafts submitted by employers during this period?
Yes, the Bombay High Court confirmed they can. The EPFO does have the authority to encash demand drafts while an appeal is pending. It's about ensuring timely collection for employee benefits.
But isn't there a risk for the employer if they win the appeal later?
There is, but there's a safeguard. The ruling explicitly states that encashment is permitted on the condition that the money will be refunded if the employer's appeal is ultimately successful.
Ah, okay. So it's sort of pay now, potentially get it back later system.
Essentially, yes. It balances the EPFO's collection duty with the employer's right to appeal and potential reimbursement.
Fair enough. And how quickly can the EPFO start recovery once they issue an order for damages and interest? Is there a waiting period?
Apparently not. The Gujarat High Court affirmed that the EPF authority can start recovery proceedings immediately after issuing the order. There's no mandatory waiting or cooling off period in the act.
Wow, okay. So employers need to react very quickly if they disagree with an order. Delay isn't really an option if you want to stop recovery actions.
That's the key takeaway. Prompt assessment and action, including seeking legal advice, are crucial.
Right. Okay, let's move beyond EPFX for a bit and look at defining the employment relationship itself. This comes up a lot with contract labor.
Absolutely. The Supreme Court provided clarity here. They ruled that if a contractor maintains the real control supervising work, approving leave, handling salary payments, then the worker is the contractor's employee.
Even if that worker is placed long-term at another company's premises.
Yes. The location doesn't determine the employer. It's about who exercises effective control over the terms of employment. The highest court said multiple postings don't change that if the contractor retains control.
So it clarifies who holds the legal responsibility about compliance, etc. It's the one with the actual control.
Precisely.
Now, shifting to disciplinary processes. What happens if an employee admits they did something wrong during an inquiry? Does the company still have to present all its evidence?
According to the Madras High Court, no. If a worker clearly and voluntarily admits guilt, the management doesn't need to go through the whole process of producing additional evidence to prove it.
Seems logical, saves time.
It does. The court basically said a detailed inquiry becomes redundant if the misconduct is acknowledged. But, and this is crucial, the admission has to be genuinely voluntary and informed. The employee needs to understand what they're admitting to.
Of course. No coercion, full understanding. Makes sense. Okay, another important concept, continuous service. How is that calculated, especially for things like retrenchment compensation under the Industrial Disputes Act?
The Rajasthan High Court gave some helpful clarification. They ruled that weekly off days, like Sundays, must be counted towards the 240-day continuous service requirement.
Even though the employee isn't actually working on those days?
Yes, and the same goes for paid holidays. They all count.
Why is that significant for workers?
It makes it easier for them to meet that 240-day threshold, which is often required to qualify for certain legal protections and benefits if they lose their job. It recognizes the employment relationship continues even on non-working paid days.
So it prevents employers from excluding those days to deny benefits. A fairer calculation.
Exactly. More realistic.
Now, what about resignations? An employee resigns. Can the employer accept it but make the acceptance date earlier than when they actually accepted it?
A firm no from the Punjab and Haryana High Court on that one. They ruled employers cannot backdate the acceptance of a resignation.
Why not?
It prevents retroactive termination. The court said a resignation only takes effect from the date it's formally accepted, not any earlier date the employee might have put on their letter or some date the employer picks later.
So it protects the employee's service record during that period between submitting the resignation and its formal acceptance.
Yes. It stops potential manipulation that could affect final dues, leave encashment, or continuity of service calculations. The employment continues until that formal acceptance.
Good safeguard. Okay, let's quickly touch on minimum wages. The Madhya Pradesh High Court looked at a 25% increase after 10 years and said it wasn't excessive. Why was that considered reasonable after such a long gap?
The court put it in context. They basically said that over a full decade, cumulative inflation was likely much higher than 25%, so the increase was actually quite modest in real terms and necessary just to maintain the basic purchasing power of the minimum wage.
Right, keeping pace with the cost of living, even if belatedly.
Exactly.
Now back to ESIC, the Employees State Insurance Corporation. We talked about EPF needing to show its work. Is it similar for ESIC assessments?
Very similar principle. The Bombay High Court ruled that ESIC cannot assess contributions based on types of payments or heads of accounts that weren't mentioned in the original show, cause notice sent to the employer.
So no surprises allowed in the final assessment order.
Pretty much. The show cause notice has to clearly state all the grounds ESIC is considering. If they add new things later, it violates procedural fairness because the employer didn't get a chance to respond to those specific points.
Transparency and fair notice again.
Okay.
What about canteen workers in a company? Are they considered employees of the main company for gratuity purposes?
Generally, no. According to the Chhattisgarh High Court, they confirm that staff working in company canteens, usually run by contractors, are not direct employees of the main establishment for gratuity.
So the gratuity obligation lies with the contractor who employs them.
Typically, yes. It again comes down to who the actual employer is based on the contract and control, not just the location of the work.
Makes sense. And what about insurance policies? If a company has multiple factories or offices, does an accident policy for one location automatically cover employees at another?
No, it doesn't. The Bombay High Court made that very clear. Accident insurance policies are usually unit-specific. Meaning each separate operating location needs to be explicitly named and covered in the policy documents for claims related to that location to be valid. You can't assume coverage extends automatically.
That's a critical point for multi-location businesses. Check your policies carefully.
Absolutely. Ensure coverage is specific to each site.
Okay. Now, a potentially sensitive issue. The Supreme Court has ruled that employers can't be forced to pay wages beyond an employee's retirement age. When does this typically come up?
Usually in disputes over wrongful termination where an employee is seeking reinstatement or back wages, the court has set a clear boundary.
So even if the termination was found unlawful, the back pay claim stops at the employee's normal retirement date.
Generally, yes. The wage compensation obligation doesn't extend past the point where the employment would have naturally ended due to retirement anyway.
Provides a definite endpoint for those claims. Now here's one that requires careful handling. Workplace comments. The Bombay High Court, in one instance, said passing comments about a female employee's hair weren't sexual harassment if relations were cordial. This sounds very context-specific.
Extremely context-specific, and it's vital to remember this might be an older ruling or interpretation, likely predating the comprehensive 2013 Sexual Harassment Act. The court focused heavily on the existing relationship and lack of malicious intent in that specific case.
So they distinguish between isolated comments in a friendly setting versus something creating a hostile environment.
Yes, that was the distinction they drew then. But honestly, workplace norms and the legal understanding of harassment have evolved significantly. The safest and frankly best approach now is to avoid personal comments altogether, especially those that could possibly be perceived as unwelcome. Relying on cordial relations is risky.
Very wise advice. Context matters, but caution and respect are paramount today. Okay, back to minimum wages. Does the government have to set different rates for different areas, like cities versus rural areas?
Not necessarily. The Madhya Pradesh High Court ruled that while authorities can set different rates based on locality, they are not legally obligated to do so.
So a uniform minimum wage across a state or region is perfectly legal?
Yes. The court confirmed that implementing a uniform rate is compliant with the law. It offers administrative simplicity, though it might not reflect cost of living differences.
Gives authorities discretion. Okay, and revisiting gratuity quickly, we know who pays it, but where do you file a claim if there's a dispute? Can you go to the labor court under the Industrial Disputes Act?
No, you can't. The Madras High Court reiterated that gratuity claims fall under the Specific Payment of Gratuity Act.
So you need to use the dedicated mechanism under that act.
Exactly. The Industrial Disputes Act authorities don't have jurisdiction. You have to go to the controlling authority appointed under the Gratuity Act.
Right forum for the right issue. Got it. Now, during a strike, things can get tense. Can a high court step in and limit who enters the company premises?
Yes. The Calcutta High Court affirmed its power to do that. It can restrict outsiders, non-employees, from entering during a strike.
Why? What's the purpose?
It's about maintaining public order and preventing the situation from escalating. The court can impose tailored limits to reduce tensions, deter potential violence, and manage security risks associated with the strike.
Balancing the right to strike with safety and order. Okay, what if gratuity payment is delayed, but it's because of a genuine, necessary administrative reason, like an audit objection? Does the employer still have to pay interest on the delay?
In that specific situation, the Orissa High Court created an exception. They ruled that if the delay is genuinely caused by a legitimate administrative procedure, like resolving an audit query, then no interest penalty should be imposed.
But the delay has to be genuinely procedural, not just stalling.
Absolutely. It's an exception for unavoidable administrative hurdles, not a free pass for employers to delay payment.
Fair enough. Now, we talk about admitting guilt in inquiries. What about the inquiry process itself? Can it be rushed?
Definitely not. The Madras High Court came down hard on an inquiry that was hurried through in just a single day. They declared it legally invalid.
Why is the speed such a critical issue?
Because rushing it denies the employee a fair chance. Natural justice requires giving the employee adequate time to understand the charges, prepare their defense, present evidence, cross-examine witnesses. Squeezing it all into one day makes that impossible.
So due process demands a reasonable time frame.
Essential. Precipitous proceedings violate the right to a fair hearing.
Okay. If an employee feels they were unfairly terminated, do they have to use the company's internal appeal process first, like understanding orders, before going to a labor court?
No, they don't. The Orissa High Court clarified that internal appeal mechanisms understanding orders are not a mandatory prerequisite.
So employees can go straight to the statutory authorities?
Yes. The court stated that statutory remedies operate independently. Employees aren't forced to exhaust internal company processes first, which could be lengthy or potentially biased. It streamlines their access to formal legal channels.
Prevents internal processes becoming a roadblock. Good. What about claiming unpaid wages? If you file the claim late, Do you absolutely need a separate formal application asking the authority to excuse the delay?
According to the Himachal Pradesh High Court, not necessarily. A separate application isn't mandatory.
How does that work then?
The Payment of Wages Authority has the discretion, under Section 15(2) of the Act, to condone the delay if the employee provides sufficient reasons for the lateness within their main wage claim application. It simplifies things.
Focuses on the substance rather than extra paperwork.
Okay. Now, once a dispute is officially sent to the labor court, can the government still issue interim orders about it?
No. The Karnataka High Court ruled that once a dispute is referred, the government loses the authority to issue interim directives on that matter.
Why is that?
Because it would be improper interference with the judicial process. The labor court now has jurisdiction, and the government can't exercise concurrent powers over something already before the court. It respects the separation of powers.
Keeps the judicial process independent.
Right. Let's circle back to EPFO claims one last time. Is there any time limit on how far back the EPFO can go to claim unpaid dues?
This is interesting. The Meghalaya High Court introduced a sort of effective limitation, suggesting claims beyond 3 years might be barred if pursuing them would cause irretrievable prejudice to the establishment.
Irretrievable prejudice. What does that mean?
It means causing harm that can't be undone, perhaps because records are gone, key personnel have left, ownership has changed, making it impossible for the current establishment to fairly defend against a very old claim.
So it's not a strict 3-year limit, but a consideration of fairness and potential harm caused by extreme delay.
Exactly. It draws on principles of natural justice and fairness from the Constitution, Article 14, balancing the EPFO's right to claim with the establishment's right to not be unfairly prejudiced by very old demands.
A pragmatic approach. Finally, we also saw rulings confirming Section 7A orders need concrete evidence, not just suspicion.
And that timely payment after a 7A assessment shields from further penalties.
Right. And that composite orders imposing both damages, 14B, and interest, 7Q, are fully appealable together.
Yes, the Karnataka High Court clarified that unified appeal process.
And we touched on appealing damage orders beyond the time limit, possibly with monthly interest deposits.
Correct. That flexibility under certain conditions.
Okay, so as we wrap up this really comprehensive deep dive into these labor law judgments, what are the big picture takeaways for you?
Well, I think a few key themes really stand out. First, the strong emphasis from the judiciary on procedural fairness, making sure bodies like EPFO and ESIC follow the rules and principles of natural justice.
Definitely saw that again and again.
Second, there's this ongoing effort to balance strict legal compliance with the practical financial realities businesses face. The installment ruling is a good example.
Right. Finding that middle ground.
Third, the courts are constantly clarifying how specific laws should be interpreted and applied, defining basic wage, who counts as an employee, which forum hears which claim. That provides needed clarity. And finally, underlying it all is a clear commitment to protecting workers' rights and ensuring they have real access to justice when needed.
Absolutely. It's clear the legal landscape is dynamic, constantly being shaped by these judicial decisions. So for you listening, think about which of these rulings hits closest to home for your situation or understanding.
Yeah, maybe one clarified something you were unsure about, or perhaps highlighted an area you need to look into more for your business or your own rights.
This has been a very thorough overview, a real deep dive into the source material of these judgments. We encourage you to explore further areas that caught your interest. Because at the end of the day, understanding how these rulings collectively shape the modern Indian workplace that balance between employer duties and employee rights is crucial.
Staying informed really is key to navigating it all effectively.
Thanks for joining us on this deep dive.